After expired 45 days, don't appear.
ये तो सही
Don't
बात है।
appear. 45 days is over. Okay. Now 45 days के बाद जो है, then
सेटलमेंट
settle अब हो जाता है. It is okay.
It's good.
नहीं होता है, then actually he देखिए वो तो खैर ये एलिगेशन तो नॉर्मल है,
हाँ
लेकिन हमारा तो एक्चुअली फेयरनेस दिखाने का यही है कि मैनेजमेंट लेटर लिखते यूनियन को कि भाई हमको जीआरसी बनानी है, आप अपने 3 आदमी का या 4 आदमी का नाम दे दीजिए।
दैट्स अ गुड वे।
तो वो जब नाम आ जाते हैं तो वो यूनियन की तरफ से आएंगे और मैनेजमेंट अपने 3 नाम दे दे, वो 1 साल के लिए वैलिड हो जाए, हर साल चेंज कर सकते हो।
तो जीआरसी में जब कोई विवाद रजिस्टर करता है तो ऐसा कोई मैंडेटरी नहीं कि एम्प्लॉई एज ए इंडिविजुअल एज ए ग्रुप जाके विवाद रजिस्टर करे।
देखिए जीआरसी तो इंडिविजुअल के लिए ही होती है,
ओके,
मास के लिए तो नहीं होती है। अब जैसे वहाँ स्ट्राइक लीगल है इलीगल तो जीआरसी डिसाइड नहीं करेगी, ठीक है ना। नॉर्मली इंडिविजुअल जो ग्रीवांस है उसी के लिए है जीआरसी, ठीक है। मास को अगर प्रॉब्लम है तो वो इंडिविजुअल ही डालेंगे। तो ये तो जीआरसी की बात होगी सर। अब मैंने वर्कमैन की डेफिनेशन बता दी, फिक्स टर्म एम्प्लॉयमेंट का भी इसमें है।
हाँ,
उसका बेनिफिट मैंने वैसे आपको बता देता हूँ। फिक्स टर्म एम्प्लॉयमेंट का बेसिकली क्या है, देखिए ये एक नई कैटेगरी ऑफ एम्प्लॉय ऐड की है। जैसे पहले हमारे यहाँ परमानेंट एम्प्लॉय होते थे, रेगुलर होते थे, कैजुअल होते थे, ठीक है ना, अप्रेंटिस हैं या ट्रेनी हैं। तो अब एक नई कैटेगरी का एम्प्लॉय जो है
फिक्स टर्म एम्प्लॉय,
ठीक है ना। उसमें फ़ायदा ये है कि इसको रिट्रेंचमेंट की डेफिनेशन से अलग कर दिया है। आप पढ़ के देखिए सर,
रिट्रेंचमेंट की
रिट्रेंचमेंट की जो डेफिनेशन है उसके नीचे लिखा है कि दिस डज नॉट इंक्लूड। आप देखिए सर, तो उसमें फिक्स टर्म भी है।
The termination by the employer of the service of a worker for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action, but does not include number one.
इसका पहला ये हुआ कि whenever you are going to terminate any employee by your discipline or otherwise, ठीक है ना। बट जो डज नॉट इंक्लूड कौन कौन सा ऐसा है जो रिट्रेंचमेंट की डेफिनेशन में नहीं आता, वो फर्स्ट है।
सबसे पहला है वॉलंटरी रिटायरमेंट।
जैसे मान लो सपोज करो कोई वॉलंटरी स्कीम आई एंड आई हैव ऑफर्ड माई सेल्फ आई वांट टू रिजाइन वॉलंटरी, तो दैट विल नॉट ट्रीटेड एज ए रिट्रेंचमेंट। सेकेंड, एक्चुअली इफ आई हैव गिवन ए सम पर्सन फॉर टाइम, क्योंकि ये फिक्स टर्म का तो हुआ है, उससे पहले भी अगर मान लो मैं 2 साल के लिए रख सकता था और आई हैव अपॉइंटेड एनी वर्कर फॉर 2 years और उसका डिस्चार्ज हो गया था, पढ़िए।
नंबर 2 है रिटायरमेंट ऑफ द वर्कर्स ऑन रीचिंग ऑफ द एज ऑफ सुपरनेशन। रिटायरमेंट की एज आएगी, रिटायर हो गया, वो रिटायरमेंट नहीं आएगा। टर्मिनेशन ऑफ सर्विस ऑफ द वर्कर एज अ रिजल्ट ऑफ नॉन रिन्यूअल ऑफ द कॉन्ट्रैक्ट ऑफ एम्प्लॉयमेंट,
जैसे मैंने 1 साल के लिए रखा और नहीं उसको रिन्यूअल हुआ, तो दैट विल नॉट कम विद इन द डेफिनेशन ऑफ रिटायरमेंट। तीसरा होगा कंटिन्यूड इल हेल्थ।
हाँ, टर्मिनेशन ऑफ सर्विस भी है। टर्मिनेशन ऑफ सर्विस ऑफ अ वर्कर इज द रिजल्ट ऑफ कंप्लीशन ऑफ 10 years, हाँ जो अभी आपने बोला, ऑफ फिक्स टर्म एम्प्लॉयमेंट।
करेक्ट।
एंड द लास्ट वन, टर्मिनेशन ऑफ सर्विस ऑफ अ वर्कर ऑन द ग्राउंड ऑफ कंटिन्यू इल हेल्थ।
अगर जैसे इल हेल्थ का मतलब वैसे ये डिस्प्यूटेड है थोड़ा सा कोर्ट में, वैसे और प्रोसेस भी बहुत लंबा है। जैसे मान लो किसी को कोई डिजीज हो जाती है और वो ही एब्सेंटिंग हिमसेल्फ, ओके, तो उसमें मेडिकल बोर्ड बैठता है, लॉन्ग प्रोसेस है। एंड व्हेन द मेडिकल बोर्ड इज गोइंग टू डिसाइड दैट एक्चुअली ही इज नॉट एबल टू वर्क ऑन दिस पोजीशन बिकॉज ऑफ द कंटिन्यूड इल हेल्थ, तो हिज सर्विसेज कैन बी टर्मिनेटेड ऑन दैट कंटिन्यूड इल हेल्थ।
देखिए, अब तक बिफोर द कोर्ट कई ऐसे केसेस हुए कि लोग इल हेल्थ का सर्टिफिकेट दिखा के रिटायरमेंट एज का काम, मतलब ऑफिस नहीं जा रहे, इल हेल्थ सर्टिफिकेट है, मेडिकल सर्टिफिकेट दिखा के नहीं जाते। एम्प्लॉय परेशान रहता है, यार ये इल हेल्थ है और एवरीवन मुझे फ्री पे करना होगा। तो ये एक रिलैक्सेशन हो गया एम्प्लॉयर के लिए टू टेक अ राइट डिसीजन।
तीसरा लास्ट में है फिक्स टर्म एम्प्लॉयमेंट में अगर, तो ये रिटायरमेंट की डेफिनेशन में नहीं आएगा, ठीक है सर।
तो रिट्रेंचमेंट हो गया, इल हेल्थ हो गई, वॉलंटरी रिटायरमेंट एंड रिटायरमेंट।
जो फिक्स टर्म एम्प्लॉयमेंट है ये बेसिकली राहुल जी मैं आपको बता दें बहुत अच्छी अपॉर्चुनिटी है एम्प्लॉयर के लिए और एम्प्लॉय के लिए। एम्प्लॉय को ये मालूम है कि आई हैव बीन केप्ट बाय द एम्प्लॉयर फॉर 1 year 2 years, so he is not going to raise any dispute after getting it that contract is ended, ठीक है ना। तो ये बहुत बड़ी अपॉर्चुनिटी है उसको, ठीक है।
फिक्स टर्म एम्प्लॉय का तो सर क्लियर हो गया कि अब फिक्स टर्म के पास क्या है कि एक इंफ्रास्ट्रक्चर आके काम कर सकता है। इन गिग वर्कर्स कैसे अपना ग्रीवांस रेज करेंगे?
गिग वर्कर का जो ग्रीवांसेस है वो एक्चुअली दैट ही कैन नॉट पुट इन द
जीआरसी नहीं कर सकता, वो किसी कंपनी में है ही नहीं।
वो थोड़ा सा हमारे एक्ट में ही है, जैसे गिग वर्कर है, अनऑर्गेनाइज वर्कर है, क्योंकि दे डजंट फॉल विद इन द डेफिनेशन ऑफ एम्प्लॉय, नाइदर एम्प्लॉय नो वर्कर्स, ठीक है। तो उसके लिए अभी है नहीं कोई प्रोसीजर, बट मे भी हो सकता है गवर्नमेंट कोई प्रोसीजर बनाए, ठीक है ना।
ये चीज़ हम सोशल सिक्योरिटी और बहुत सारी चीज़ें दे रहे हैं, तो कहीं ना कहीं ऐसा भी हो सकता है कि गिग वर्कर्स का अपना ग्रीवांस है, जैसे 10 मिनट में उनको डिलीवरी करने का एक प्रेशर रहता है जो रिस्क हाई करता है ट्रैफिक में गाड़ियाँ चलाते समय, या फिर धूप हो या बारिश हो, जैसा भी सिचुएशन है उसमें
अभी उनके लिए गवर्नमेंट ने कोई स्कीम नहीं बनाई है। आपका ऑब्जर्वेशन बहुत सही है कि वो कहाँ अपनी ग्रीवांस
रेस करे,
रेस,
कौन सा डर लगा खटखटाएंगे,
हाँ, क्योंकि वो IR में भी नहीं आते जी, ठीक है ना।
और उम्मीद कर सकते हैं कि
हो सकता है गवर्नमेंट कुछ बनाए।
तो सर ये तो चीज़ समझ गया कि जीआरसी का जो रोल है
वो एक लीगल रोल है सर, पहले नहीं था GRC का लीगल रोल, लेकिन अब इस एक्ट के बाद आ गया है,
दे रिसीव द ऑथोरिटी,
इस एक्ट के बाद आ गया है, ठीक है। तो मैं तो आपसे यही कहूँगा कि GRC जो है इसमें जो कंसल्टेंट का काम है, अपने जितने भी 20 या 20 से ज़्यादा हैं वहाँ GRC कमेटी बनाए और वहाँ SOP भी बनाए, स्टैंडिंग ऑपरेटिंग सिस्टम।
मेरी एक ग्रुप कंपनी फॉर एग्जांपल एक ग्रुप कंपनी है और मेरे पास मेरे ग्रुप में कई सारी छोटी छोटी कंपनियां हैं, तो मेरा एक जीआरसी जो है कम्युनिटी वो सभी ग्रुप्स के लिए एप्लीकेबल हो सकता है कि
नो नो, एक वन प्लेस, इफ यू आर हैविंग डिफरेंट प्लेस तो डिफरेंट बनानी पड़ेगी। इसमें लिखा है मोर देन वन,
हाँ वो तो ऑप्शन दिया ना कि एक एम्प्लॉयर चाहे तो बना सके।
ठीक है, अब मान लो सपोज करो एक आपकी कंपनी गोरेगांव में है,
हाँ,
और दूसरी एस्टैब्लिशमेंट में, और एक एक्चुअली आपके
दिल्ली
बांद्रा में या थाने में, तो बट मेडिकल एक्चुअली वो थाने से ना तो गोरेगांव रिपोर्ट करने के लिए आ सकता है, ना ही गोरेगांव से वहाँ। तो अगर उस पर्टिकुलर एस्टैब्लिशमेंट में 20 या 20 से ज़्यादा है तो वहीं कमेटी बनानी पड़ेगी।
तो हम जीआरसी ऑनलाइन प्लेटफॉर्म में नहीं कर सकते पूरे कंपनी के लिए कि किसी को कोई भी कंपनी ने आप ऑनलाइन मेल डालिए?
ऑनलाइन तो रजिस्ट्रेशन तो हो जाएगा, बुलाना तो पर्सनली फेस टू फेस करना पड़ेगा।
हाँ, राइट टू हियरिंग जो है वो आप
हियरिंग तो आपको उसको देनी पड़ेगी। तो मैं तो एक्चुअली सजेस्ट नहीं करता, ठीक है ना, क्योंकि बेसिकली ये खाली पेपर फॉर्मेलिटी नहीं होगी, ये कमेटी ये एम्प्लॉयर को 100% हाँ मैंडेटरी है और बनानी पड़ेगी, क्योंकि बगैर इसके आप लेबर कोर्ट में कंसिलेशन में अप्रोच नहीं कर
सकते आपको,
ठीक है ना।
कितने दिन के अंदर बनाना चाहिए? जैसे 20 हेड काउंट हो गया इमीडिएटली विद 30 डेज 60 डेज?
इसमें टाइम लिमिट नहीं है, बस ये है कि एज सुन एज यू आर रीचिंग 20 और मोर यू हैव टू मेक द डिमांड। इसमें ये भी नहीं है कि ये कोर्ट लागू होने के इतने दिन बाद आपको बनानी पड़ेगा। हम तो ये कहेंगे जैसे ही लागू हो जाए,
हाँ डेफिनेटली एडवाइस तो सही है कि जैसे
एज अर्ली एज पॉसिबल,
बट अगर नहीं भी बना है
Hello, mic testing. Hello. Hello. Good morning, Hyderabad. And thanks for making it possible. I'm really mesmerized by the level of hospitality by Hyderabad delegates. Thanks once again that making this event successful, houseful event. During the time of electronic media or virtual world, we are making it possible together in this room. So I would like, please clap for yourself that yes, you all have done it. And now is and now is the time that all our dignitaries will have their place. So I will request my team that please escort our chief guest and other dignitaries for the room so that we can start the events. So now event is going to be start in next couple of minutes. So please relax. You all have your kits. Just have a look on that kit. You will have your our monthly label or journal. For writing purpose, your notebook is available, your pen, and definitely at end of the event, you will receive your certificates also, which is available. Okay, team. Anyway, our chief guest is here, and I will request Niranjan sir, please take the podium. And sir. Thanks everyone. Well, we are committed to start by 10 a.m., but somehow, after looking use, we are quite shifting time to 10:30 a.m. Now we are going to start. So today, at this room, at this forum, we are blessed by the presence of our chief guest, Mr. R. Chandrasekhar Raman sir. He is the Joint Commissioner at Labor Department and he is heading the entire Telangana state. Not only this, if I have to say about his achievement, he had played a vital role being a nodal officer for ease of doing business initiative for the country. And at present, he is also the nodal officer for Hyderabad, Telangana labor code rule drafting. So, sir, we are really pleased that you are here and blessing us with your presence. With this, I would also like to introduce Shetty sir, who has been there for us since around, I believe, sir, around 3 decades minimum. So he's having his own expertise into gratuity and insurances area, which definitely he will come across and speak. So here now I will announce to have this Dia Div Jyoti inauguration before starting this event. So sir and all my dignitaries, speakers, please help us. Yajat, S.K. Gupta ji, Devan sir, Jayant Saligram sir, Ranjan Rao sir, and Govind Raj ji, please. Hello. I will request Mr. Nitin Kumbar, the COO of Click Nexi, to please have a bouquet to our honorable chief guest. Sir. Sir, we have our author and speaker, Mr. Govind Raju, NS, and he has recently published India's first IR code commentary book. So I will request him to please have it for the Chandrasekhar sir. Sir. Sure. I will also request Niranjan Rao sir, Jain Saligram sir, Gupta sir, Yajat, please have a place at the podium. Please. Chair. That's it. हाँ दिवेश गोविंद जी So ladies and gentlemen, I am Rahul Kuwar, Chief Vision Officer of Compliance Leadership Intellectual Community of Knowledge and Nexus, means Click Nexi. When this labor code come into picture, I was just sitting like this as you all are here, somewhere at in Mumbai. And immediately I come to my YouTube channel, Compliance Monk, and I started speaking about what this new code is. And after doing couple of episodes over my YouTube channel, it was, this is what I feel that, no, this virtual explanation may not work. We need something concrete. We must be available. You know, somebody said that future is uncertain. And what I say, future is absolutely certain if you decide what you have to do today. That point of time, we decided that we will start conducting at pan-India level, we will pay visit each and every possible cities to have offline event, seminar. The code get published on 21st November 2025. Click Nexi team started offline event. Their first event were on 6th of December. It was hardly 15 days. We had our first event at Mumbai. Then and after looking after response that people are interested for the offline events, we got motivated. We really been motivated to have the delegates like you throughout the country. Then we had our first national seminar at Mumbai with 250 delegates. Then we headed to Pune, and after that we went to the capital of India, Delhi, where 450 delegates were present. Not only from India, people were from Japan, China, Germany, France. Even one of our chief guests, Miss G, who is the CHRO of Realme. She just come down from Beijing for what happening in India. So here I would like to mention that whatever things are happening in India in the field of labor law is not only the topic of interest for the citizen of India, it is the topic of interest for the citizen of entire world. If everyone is looking us that what India is going to do, what they are doing for the ease of business. So with that determination, with that object, with that small thought that yes, we will do, This is our third national seminar, and we are really blessed to have the wonderful hosting by the Hyderabad. Thanks. I will again request, please clap for yourself that you all have made it possible for us. The entire effort made by us, it won't be having such kind of tasteful foods without your presence. I must like to mention the Labour Law Reporter and HL Kumar Association team, the way they become backbone for ClickNexi. They understand, they were the first and the titan of this entire industry who understand that yes, and agreed and in line with our vision. From that day till today, for each and every small or major event, we all are doing together. And not only we are conducting events, we are also ensuring that whoever is being participating in any of our event, any point of time, if they are having any doubts, we are trying our best possible efforts to support them. So while being present here, you are not only participating, you are also becoming the member of ClickNexi Compliance Community Group. You are also becoming the associated with Labour Law Reporter team. I'm very much confident that almost maybe 100% I would like to say that we all grown up while reading H.L. Kumar sir books, right? Means it might be hardly possible that anybody might not knowing his name or might never read his books or journal. And if not, then today is a day. You all are having one copy of our this current month journal in your hand, in your joining kit. Sorry, not joining kit, since I am into profession, employee join karte, so I used to say joining kit. It's your event kit. In this event kit, yes, you are having your Labour Law Monthly Journal, then your certificate copy, your notebook where you have to mention, and also the signature pen by Pere Cardin for ClickNexi. So that is also available for you. And from this, I will say, let's make each and every moment of this day utilize properly and enjoy this learning event, so that when you will leave this room after 5 p.m., definitely you are not going alone. You are going with a wonderful memories that today Labour Law Reporter team, ClickNexi team, Sarsota, Saksham, Yuva Shakti Foundation, and my good friend Indy Think team. Unfortunately, he is not available here due to some unavoidable circumstances. Okay, but we all had put strong efforts, and we want you to have those memory when you are going to leave today. With this, I would like to rest myself, and I would like to introduce my learned senior advocate Niranjan Rao sir to take it ahead this session. You have to ask him. You will introduce the sir. Okay. Actually, I want you to invite him, sir. Okay, now there is a change, and change is only permanent. So, sir, over to you, sir.
Thank you.
And thanks, sir. Thanks for your blessing and being here.
Thank you once again. Good morning, all. Good morning to the dignitaries in the dais of the dais. It's nice to be between all of you again. I hope most of you are practicing HR, right? Can you raise hand who are in HR functions? Yeah, I think 90%. Okay, that's good. I know we are in the transition. Okay, old to new, everybody wants to be up to date. And the learning curve will be there for everybody. See, the little background before we talk about, what we are going through now. When the economy opened in 90s, the first and foremost question many MNCs raised is about the rigidity in the labor laws in India, right? in 90s when the economy opened. Then government decided to bring the reforms in labor laws. Because you know the labor laws, most common complaint is you got multiple laws, pre-independence era laws, you know, they're not in line with the technology changes, okay? Internet of Things, electronic communication, you know. Not only that, each law has got one inspector, a set of registers and records to be maintained. You know, if you look back, under 44 laws, I'm sure about all the 44 laws will have one wage register, one muster roll, all those things. Lot of duplicity of efforts also there in that. So with this background, government decided to reform it with that intention. It set up a second National Labour Commission. You know that Ravindra Verma is headed that in the year 1999. Okay. So they took 3 years time. Finally, they came with the recommendations to consolidate all the labor laws, bring them together and bring 4 codes instead of all the 44. Actually, in fact, way back in 2001, 2002, I heard about this bringing existing laws goes away and 4 new labor codes will come in the year 2002. Now we are in, I think we are too fast to do the things. I think I wish governments will, you know, bring whatever they want to do much faster way, because even bringing the law itself took long time, 2000, you know, 22, 20, but still rules also almost like 4 years, 5 years. I wish things, because the world is in a faster pace now in the global economy, you know, things won't work this way. We need to be fast decision making, fast implementation, align with the global changes very quickly. I think at least hopefully things will quickly roll out in every state and will be keep up and running with the new system. Okay, so this is the scenario. In this, a lot of the problem is, you know, it's a democracy, right? You need to consult everybody, you need to consider everybody's opinion. So, yeah, it took some time, but finally I think things are better. Especially, I can tell you, for business point of view, lot of reduction you can see in complaints. Close to 50% I can say, you can number of sections to be complied or number of, you know, returns or filing. The biggest change what I like it is, you know, one single registration across all the 4 codes, one single license, and the concept called national license. These are all really helpful to you. Okay, so this kind of changes hopefully reduce the cost of complaints. At the end of the day, for a business, you know, I still remember when we started doing some exercise, how to reduce the complaints burden to the industry. I realized there are close to 75 notices to be issued by the business to the department, and close to 22 display requirements. Display requirements, you display minimum wage act or your labor license or that license, this. Probably you need to set up a room for displays only. So that was the scenario. Yeah, luckily I think all those things are gone now. So yeah, but still, you know, it's easy to say when you bring some reforms, but impact, you never know what would be its impact. One example start with that, way back in 2003, in combined state, Andhra Pradesh government, we are the first one to bring this contract labor amendment. I think many of you are aware. Okay, only core activity contract labor not to be employed, otherwise rest of the cases, you need not go through the regulation and you know, all those things. You know, those days there used to be separate body to recommend industry-wise where you can employ, where you cannot employ. We thought we simplified little bit, reduce the government role. We really didn't realize, knowingly, unknowingly, the contractualization increased manifold. You know, the issue is not that. The unforeseen impact is, suddenly, the bargaining power of all the regular employees have come down. The reason, their numbers have slowly over a period of time came down and contractualization increased. They are not in a position to dictate the terms. So such a small change, if you see like post 2000, 2003, because we are in the field of conciliation, right? We are the first one to know how is the industrial harmony in the state of Telangana. So where strikes are happening, where issues are there. I'm telling you, the 90s, we used to see almost like weekly one strike. Post 2003, this one single reform brought in so much change, workers' bargaining capacity has come down. So I don't know whether it's good or not. So why I took this example is one change brought in so much change. Now we are here with so many new reforms, so many new changes. Even I don't know, time will tell which reform takes which form and ultimately what will be the IR scenario going forward, because quite a lot of, even till today also, say for example, you see, there are, everybody knows, there are in public domain, there are unions also, I got quite a lot of, concerns about these reforms. Even now they are not happy, in fact. Say for example, what do you call this? FTA. Right? Everybody are worried. Will there be only FTAs in future? Only government will have regular employment everywhere, FTAs? Probably. So, I don't know. See, FTA experiment, actually you know that Bangladesh model, it started with that, right? Everybody aware of why this FTA concept came forward. So the Bangladesh industry, it's mostly FTA. That is why in India also way back in 2018, when standing amendments to the Industrial Employment Act, Government of India brought in, it mainly primarily notified that industry only, textile industry, with the condition that, okay, in the process you should not replace any of your regular roles. But impact is not much actually. I have seen that, not many FTAs, though it's there, of course, some states, they have not made amendments, though some states took it forward. But not much. It's not much as much as we hoped. That's the reason I will tell even some people when they came to me worrying about your FTA thing. Yeah, and on small level pilot project, it's done, and not much. So it may not be. We don't know. Time will tell. These examples. That's why when you are talking about reforms, same way probably MSMEs. I think they will be much better off, especially closer layoffs, retrenchments up to 300, threshold 100 to 300 now made it. So it's not that you need to run to the government for seeking permissions. But the problem is majority of our industry is in that sector only, below 300. So definitely they feel they are now less protected. FT is here, threshold is increased, and you cannot go on a strike without notice, compulsorily. It's like as good as every industry is a public utility service now. Otherwise it amounts to illegal strike. So all these factors, still there is a resistance from the unions, and they are also worried. One more major reform change, of course, it's you may say we are already having code of discipline in place, okay. But the thing is, now we made it statutory. Earlier it's just non-statutory administrative function, or it's just a code. Okay, similar lines. It is similar sign. Only difference is now we said, unless you got 51%, you cannot be recognized union. You need to go through the, if proportionate to your voting you received, negotiating council will be formed. I think this will have huge impact in IR, according to me, because when with simple majority you got an option to elect your recognized union, normally always there will be scope for like one-upmanship, you call it, right? You promise something, of course, whether you fulfill it or not, that is the secondary. But every small group try to promise something which is not in their control. It's not that they provide that, they give that. It's ultimately it's a management who has to agree for your conditions. But that one-upmanship environment, I think slowly goes away, which is good for the industry. It will help industrial harmony, I'm sure. Because with our experience, what we noticed is, we got few industries, there will be one union, only one union. There will be panel elections. You will have multiple panel competing for the same union president, secretary or office bearers. It's not multiple unions. We got like VST or few industries we have seen. We've seen very healthy environment in such a scenario. Okay, it's not multiple union competing. Within the panel you compete for one union, one union will be the always a recognized union. It's like we have been observing since 30, 40 years. They are doing very well. In fact, long back, probably you may be knowing the name of Mr. Nayani Narasimha Reddy. He was a senior most trade union leader. Not only that, he is the labor minister for quite some time. His industry stalwart, you can say that. He tried to mute this idea of why can't we implement one union across the state? One industry, one union. Probably you may have panels. That way there will be a better, environment. So that, of course, we could not achieve, but through this new labor code reform, negotiating council, negotiating union, probably we are heading toward that, to achieving that goal. So these are like, appears to be small things. Of course, compliance, checklist, all those things, anyway, you understand well. You know how to do those things, but the impact I'm looking forward. So how these changes is going to be affecting the whole industry. But I'm quite positive and optimistic also. It's not as negative as some people are thinking, and at the same time not as sweeping, like, changes won't happen overnight. Only time will tell. I can say that. Okay, coming to the, I think since it's in Hyderabad, most of you are from Hyderabad-based industry. I'm sure you will be interested what's the status in the state of Telangana about new labor codes and laws. Rules, I mean. So we are also now in a fast track mode. Okay, so you all already know that we already notified the draft rules, and we revised the drafts basing on the feedback we kept in the public domain. Last week also we held a series of consultations with the industry as well as trade unions to check are they okay with that, because we wanted to listen to the stakeholders. We don't want to rush the things. So we are there, almost there. So once this is done, final rules will be published. Actually, in fact, we don't have time. Every state is stepping into complete, even central government following it up with us to speed up this whole process. So probably sometime, hopefully sometime in July, we will see, because it's the government who takes the final call, right? It has to go through the law department and gazette publication. Yeah, but July is a key, important month for us. Many activities are planned to be rolled out, so we'll see. Time will tell. Anyway, I think thank you for inviting me for this, a good meeting, professional body meeting. I'm always happy to be amongst all of you, and we got really a big stalwarts in the industry. I wish I also am one of the participants, but I got another meeting to go. But you see, learning always important thing. Okay, we should never see that we know everything. That means the moment you feel that you know something, you are outdated. The enthusiasm to learn, the inclination to learn should always be there as long as we are working. Okay, please update, upkeep, and clarify all questions and doubts. In fact, I am happy actually to note this LLR is the name part of this, this associated with this meeting, because when we are young kids, when we are early in our services, it's pre-internet of things, right? To know some information or what is the latest case laws, it's the LLR which used to, LLJ, LLR, those are the magazines which we used to heavily depend on them to gain the insight or judicial interpretations and what are the latest happening in the labor laws. So they are like industry, you know, you can say a good resource people. They are also part of this meeting, associated with this meeting. I think that's a very good thing because it's a well-known national body. Yeah, I think that's it from my side. Thank you very much for welcoming me.
Yeah. Good morning, all of you. Hope many of the people sitting here may not require my introduction. Therefore, no introductory remarks are given about myself and Chandrasekharam Garu, because both of us belongs to the state, and all of you are constantly in touch with both of us. So therefore, to save the time, we are not getting into the introduction issues. So a warm welcome to all of you, to the dignitaries on stage, sir. Particularly a thanks to Chandrasekharan Garu for accepting my invitation just over a phone call with a short notice. So he has gracefully accepted my invitation and came here. And I also welcome S.K. Gupta ji. Thank you for coming to Hyderabad, sir. Govind ji, sir. And Jayant Shaligram ji, Devesh Tripathi, and finally Ajat Kumar, who is the grandson of H.L. Kumar. He is the founder of LLR. He is also here. He is also taking one session on IR code. Yes, sir? Yes. So you will hear him how, even though H.L. Kumar Saab has not visited to Hyderabad, despite of many requests due to his health reasons, he was not able to come to Hyderabad despite of many requests made by me. So gracefully now, his grandson is here. So thank you, sir, for coming. I welcome all of you on behalf of all the participants from Hyderabad, sir. Have a wonderful session today. Sir, the new labor codes, which was now a big issue across the country, was replaced about 29 central labor legislations. But state legislations are still going to continue. That is Shops and Establishments Act, Labor Welfare Fund Act, and National and Festival Holidays Act are still going to be in force despite of the introduction of labor codes made by the central government. So these three state laws are going to be continue with us. And now earlier, if you see what is the reason for making these labor codes, many of the labor laws were made prior to the independence. You can see 1936 was the Payment of Wages Act. So the other act, 1926 is the Trade Union Act. And the other one is the Workmen Compensation Act, 1926. These are the pre-independence enactments. After the independence also, hardly we made any few laws. ID Act 1947, Minimum Wages Act 1948, Payment of Provident Fund Act 1952, ESI Act of 1948, and the latest one was Gratuity Act in 1971. If you see this scenario, after 1971, there was no labor law recently amended or recently formed by the government of India. We are only continue with that old laws by making required amendments. Time and again, those laws are being amended as per the day-to-day convenience. That means the old bride with a new sari. The bride is the same. We are changing the saris whenever we require. So therefore, the laws which was outdated or required some modification was the reason for making this kind of a labor law compendium. Now, all the 29 laws now became 4 labor codes, and now instead of carrying 29 books, we can carry only 4 books. That is the major thing happened. And now in this labor code, if entire session may be only going to be focused or confused with the word wages. That is the definition which is going to create a lot of confusion which runs into 43 lines, if I'm right. It runs into 43 lines definition, and a worker definition runs into 23 lines. So these are the issues where you have to have many questions on the speakers, and you require a lot of clarity how that wages definition has to be interpreted. It has an inclusive portion, it has an exclusive portion, and any amount which exceeds 50% of the exclusion will add back to the inclusion portion. That is the confusion. So that wage definition itself, because it has an impact on you for the ESI, EPF, gratuity, bonus, leave encashment, everything is now to be calculated basing on this wages definition. So this clarity is required for understanding how to interpret and how to navigate your HR policies. And several FAQs and several interpretations and clarifications are given by the Government of India, by ESI Corporation and EPF authorities also. But this clarity, how this wages has to be interpreted and what items to be included and what cannot be included, has still remained in an uncertain area. We have to live together for some more period, according to me, until a judicial pronouncement is given by the Supreme Court or State High Court. This confusion still will continue, because if you see the WhatsApp, several kinds of interpretations are being given. Somebody is saying it inclusive, somebody's case it's not inclusive. Somebody said that only the items mentioned in A to I are to be required to be considered, other allowances not to be covered. Several kinds of interpretation are being circulated, which is creating a lot of problems for implementation of this act. And interestingly, this code has come into force on 21st November 2025. Many confusions are still there, saying that it has not come into force. State rules have not been formed. Central rules are recently notified on May 8th. So therefore, the code has not to be implemented unless some other notification has been issued. So kindly take it from this conference that code has already came into force. You have to implement from the November 2025. The state rules or central rules or notifications, anything, will only supplement the which is given under the code. It is not going to rewrite the code already been notified. It has came into force from November 2025. Suppose PF, ESI and other things has to be paid from November 2025 only as per the amended new provisions. So I get many queries every day. Sir, still we have time. We will pay it later. We will, because no state rules are formed. That is the major confusion across the many HR professionals, saying that still we have time. No, sir, please take it. It is already came into force. So you have to start complying with the provisions of labor code. Now, with regard to the ESI Corporation, I will throw some questions open to the floor. Thereby, the panelists also will be easy to answer you. Suppose under the ESI Act, there was one rumor spreading across the WhatsApp university saying that even the employee drawing 42,000 also is required to be covered under the ESI. Most of you have also had the same doubt. But the ceiling limit under the ESI Act is still 21,000. That has not been increased or not been withdrawn. Still, as per the ESI Act, it is only 21,000 is the ceiling limit. But whereas some interpretation says even 42,000 drawing employee, because his 50% salary will be 20,000, therefore he is required to be covered. Whether it is correct, whether the ESI Act is to be paid for the person who is drawing 42,000 also. We made this question to the Regional Director of ESI Authority Corporation. He is giving an answer which is neither this side nor that side. He is simply saying you read the FAQs issued by the ESI authorities. You please read the Social Security Code. That is the answer. Reading is also we can do. But what is the interpretation? So how can we say that a person above the ceiling limit has to be covered? Now, surprisingly, the PF authorities have given a clarification saying that PF has to be paid only up to 15,000. So when the PF is applicable only on 15,000, and the contributions has to be paid only basically on 50% of that, how can the ESI Corporation can interpret it in a different manner, which are both covered under the Social Security Code, EPF and ESI, are under the Social Security Code, and the wage definition is the same for both of them. So how can one department interpret it in a one way and the other department, their sister department, interpret the manner in different manner? So this is another confusion which is creating a lot of issues in implementation of the act. And similarly, the construction workers. Any participant from the construction industry? Yeah, I know few of you. So construction industry, suppose a construction worker is not covered under ESI Act because the ESI authorities have given a notification. Supreme Court granted a stay of implementation of construction workers. Now, because of the new definition of worker, the ESI authorities are saying even construction workers are to be covered. Then what happens to the judgment of Supreme Court? Is it deemed to have been withdrawn or nullified? No answer from the ESI authorities. So as long as the Supreme Court judgment continues to hold the field, that cannot be interpreted in a different manner saying that you have to be covered under the ESI Act because the definition of a worker has been changed. Interestingly, the answer of the ESI Corporation is that judgment was given under ESI Act. This is under the Social Security Code. Therefore, you have to go to Supreme Court, get it modified. That was the way of the answers we are getting from the ESA authorities and the PF authorities. They have also no clarity with the due respects to them. Nobody has had the clarity to say correctly this is the legal position. Nobody in a position to give the correct answer, don't interpret or interpret like this. With due respects to Chandrasekharan Garu, their department is still better because there is no financial implications with the labor department. Whereas PF and ESI have the legal financial implications. If you don't pay this month, you will have to pay 12% interest and 25% damages, which is equivalent to 37%. So that kind of liability starts running. So November 2025, the act came into force. We are in the June. So already 6 months have gone. So for these arrears has to be paid along with interest and damages. So how can it be answered? That this forum will answer you what is the correct legal position, how to interpret this law. And similarly, sir, the labor codes, which made with a lot of enthusiasm, which was revamping or modifying the existing labor laws into with a great vision, ease of doing business, wonderful jugglery of words are being used to codify this. But what exactly these codes have done, if you look at it, it is a consolidation of old laws. Instead of 29 books, we are carrying 4 books. Most of the existing provisions are copied and pasted. Majority of them are copied and pasted. And these codes are not meeting the present day requirements. Any persons from software industries? ITES? Yeah, Nagaraj. Yes, sir. So the industry which is having the problem is basically employee leaving the services without completing the bond period or agreement period, joining with a competitor without completing the exit formalities, moonlighting, disclosing the confidential information to the other competitor companies. These are the issues boiling on the day-to-day administration. If you look at it, even the worker also, the people are taking this kind of non-disclosure agreements, non-competitor joining agreements. This is the day. This is the order of the day. People are taking this kind of an agreements from the employees, where these employees are making breach to this kind of agreements and joining with a competitor. Now the labor code, instead of answering this kind of a day-to-day regular requirements, have simply followed the whatever in 1947, is still brought here and continuing now. If after 50 years of independence we want to make it a better legal position, it must have done in a better way by taking the advice of all the actively participating, practicing members without taking their views. Just something has done, majorly 6 or 7 are the major amendments in this, that has going to create a lot of litigation and problems in future. Except 7 or 8 are the main amendments, including wages, worker, employee, FTE. appropriate government. These are the 7 or 8 definitions which they change. These 7, 8 are going to create litigation. And these are 8 going to create a lot of problems in future. On the other hand, if you look at the flip side of this, what this code has done, it has dismantled the established legal institutions. It has dismantled. Labor court is there from 1947 under the ID Act. Now they have abolished. In the place of labor court, industrial tribunal with the 2 members have been now introduced. And this industrial tribunal is unfortunately given the power of granting interim relief to a worker in case of discharge, dismissal, or termination. So now a worker or an employee, if you want to terminate, you conduct a domestic inquiry, issue a charge sheet, conduct a domestic inquiry, and in the domestic inquiry, you may say that you will not be allowed to bring a lawyer to participate in the inquiry. This worker can go and file a case before the industrial tribunal saying that I am not allowed to have an advocate of my choice in the inquiry. This is a violation of principles of natural justice. Management is represented by some consultant or a lawyer. So the industrial tribunal may grant a stay of that proceedings. So the whole proceedings will come to a halt. Earlier, sir, you are all aware, labor courts does not have this power to grant interim relief. They can only decide the case on merits after the full-fledged trial. Now, by giving this kind of an interim relief power, it is going to affect where the trade unions are strong. Any trade union leader can say, I'm going to be victimized because of my trade union activity. So therefore, grant me stay. Fortunately or unfortunately, if industrial tribunal grants stay, you are gone. Getting it vacated and then going to High Court to get that order quashed, it takes a lot of time. So this giving that kind of power, nowhere in the state it was there earlier, except Maharashtra. No other state had this kind of power granting interim relief without deciding the main case. Now they have introduced this in this code. This is going to create an IR issue, according to me. Your labor department may say that you may not admit into conciliation on ground. So he is not a manager. He's a manager, he is not a workman. If you refuse, that fellow will go to the industrial tribunal and file a petition and seek an interim direction. Let me continue. So without deciding the merits of the case, if the interim injunction is given, that is very difficult for us to get it vacated and proceed with the trial. So this kind of introduction of a new provision is going to impact the business requirements. It is not in the best interest of the industry or for the employers. Employee may create any kind of problem, but it is difficult for the employers to address this kind of things. I also further conclude that the code which came in this present mode must have been drafted in a better manner, but it is not going to answer the present day requirements, even though it has some social vision. So creating some kind of, as per the ILO conventions, that was I was told, many of these were made because of the ILO conventions. But if you strictly look into this, it is not meeting the day-to-day requirements. Rather, it is going to create a confusions on many of the areas and going to create a lot of litigation. Hopefully for advocates it is better. Practicing advocates, few of us are here. For us it may be better, but it is not, in the long run, it is not good for the industry. So with these few remarks, I conclude my opening remark. And I wish all of you are actively participate. This is a great opportunity for all of us. All the stalwarts who are practicing across the India are here. It is a very rare opportunity to bring them all on one platform. So please make use of it. Have few questions or ask all our your practical day-to-day issues. Raise the issues which I also raised, please, on my behalf. How an ESI Act has to be implemented. Those issues, I also need some clarification through you. Please make use of the opportunity and have a wonderful session. Thank you.
Thanks, Niranjan sir. Without your this starting tone, okay, for this event, I don't think that we are going to set our mind that what actually we need. Thanks a lot. Now I will request all my dignitaries that we can start our scheduled sessions on each and every code one by one. मैं बुलाता हूँ. I will introduce. So here Chandrasekhar sir is meeting with their old colleague also. I think it's an alumni meet, right, sir? Anyway, so since morning we are discussing one thing very oftenly about labor law reporter. So ladies and gentlemen, I would like to introduce you Mr. Yajat Kumar, the third generation leader for labor law reporter, and quite young and too much knowledgeable on this subject. Yajat, I would like to welcome you on the stage. Please.
The honorable. Am I audible? Just to ensure that I am audible at the back, you can give me a thumbs up. Good. The Honorable Joint Labour Commissioner, who had blessed us with his benign presence, Shri Niranjan Rao, Advocate, Telangana High Court and Senior Labour Laws Consultant, whom I hold in great stead and who I placed next to my grandfather, late Shri H.L. Kumar. Advocate S.K. Gupta, practicing before the Supreme Court of India, whose exuberance and energy never fails to amaze me and who has been my compatriot in many seminars. Shri Jayan Shaligram, Advocate Bombay High Court, with whom I share a Guru-Shishya bond. Shri Govind Raju, Senior Labour Laws Consultant. Shri Devesh Tripathi, Advocate Allahabad High Court. Other dignitaries, ladies and gentlemen. Just before that, can we have a huge round of applause for them? And for Mr. Rahul especially, he has taken much pains in organizing this seminar and beautifully so. Good morning, my name is Yajat Kumar and I am the editor of the Labour Law Reporter. I am also an associate of H.L. Kumar and Associates and a practicing advocate as well. At the very outset, I would like to congratulate and commend Shri Niranjan Rao on the wonderful primer that he gave on the labour codes. And I do agree and resonate with him on the fact that while the labour codes, have brought in a new ray of hope, they have also put forth before us a new set of challenges. I think that the most difficult challenge that we are facing at the moment is that of implementation, and not just implementation simpliciter, but effective implementation. We all know that the central rules have come into force, right? But effective implementation for most organizations, because for most organizations, obviously the appropriate government is the state government for majority of the organizations. And for them, effective implementation is only possible once the state rules are notified. Now, that the state rules are not notified, it is obviously not possible for you to carry a lot of compliances, such as the forming of the grievance redressal committee, maintaining registers, forms, returns, etc., and many other compliances as well. But I think that more than implementation, a challenge which weighs heavily on the mind of a lot of HR professionals and legal professionals as well is that of interpretation. We all understand that law is a subject which is largely riddled by subjectivity, especially the labor laws of India, which are constantly in a state of flux. And this subjectivity has given rise to a lot of problems in the past as well. I'll give you a simple example. In 2019, the Supreme Court had pronounced the judgment of Vivekananda Vidya Mandir with respect to Provident Fund. Now, what was happening before was that a lot of people were contributing PF contributions only on the basic salary and not on other allowances, which were being paid ordinarily, universally, and necessarily. And the Supreme Court, held that you had to pay Provident Fund contribution on these allowances as well, which were nomenclatured as special allowances, other allowances, so on and so forth. Now, when the Supreme Court gave that decision, it left a lot of employers precariously poised. Because now not only did you have to pay your Provident Fund contributions from a retrospective period, but you also had to pay damages and interest along with that. And Gupta ji knows that many of these proceedings are still pending pertaining to damages under 14B and interest under Section 7Q of the EPF Act. There are other examples as well which have, left the employers precariously poised owing to subjective interpretational differences. For instance, splitting of minimum wages for the purposes of Provident Fund contributions under the old law. Many people were saying that it is not possible. Even the Punjab and Haryana High Court, the single judge held that it was not possible. Later, the matter went on the Supreme Court, and the Supreme Court said nothing doing, and that you can split minimum wages for the purposes of Provident Fund contribution. A similar instance had happened with respect to the judgment of Marathwada Grameen Bank, wherein it was held that even if you are contributing above 15,000, you can always bring it back to rupees 15,000 for the purpose of PF contributions. So, even though the law is riddled with subjectivity, our endeavor as consultants and advocates and advisors is always to stray away from subjectivity, even though it has its perils. Obviously, it is not possible for us to give a final say on anything, because that is the job of the judiciary and the judges. With that in mind, and with those guiding principles, let me begin with my session. Can we have the second slide? So this is just basic. Of course, the Code on Wages, Code on Social Security, Occupational Safety, Health and Conditions Code will be dealt with by our other speakers. But insofar as the Industrial Relations Code is concerned, which I shall be dealing with mostly, of course, I'll be meandering away in between, and I shall be dealing with the provisions of the other codes as well, albeit in a peripheral manner, so that you get a basic understanding, and I am able to connect the provisions of the IR code with the provisions of the other code as well. Next slide, please. Next. All of this will be dealt with by the other speaker. Yes. So the IR code subsumes three laws: the Industrial Disputes Act of 1947, the Industrial Employment Standing Orders Act of 1946, and the Trade Unions Act of 1926. So on the basis of its ambit and its scope, it's perhaps the most truncated law, because it only subsumes within its ambit three laws. Other codes such as the such as the OSH code, the Code on Social Security, etc., they take into its ambit a lot many laws. Next, please. Just go before that. Yes. So let me first deal with the genesis of the IR code, right? So when the IR code was initially brought into effect, there was a lot of confusion as to whether the existing labor codes and the industrial tribunals could deal with the previous cases as well as the new cases. Because the IR code in no uncertain terms states that the old labor codes and the industrial tribunals will be abolished, and you will now have new industrial tribunals which will be presided over by two members. One is the judicial member and the other is the administrative member, like we have in central administrative tribunals and NCLAT, NCLTs, etc. But many people were of the opinion that since the current labor courts and the industrial tribunals are existing, so they cannot deal with the previous cases and the new cases, because even the previous cases were to be transferred to the new industrial tribunals. So to solve this problem, because someone had filed a case before the Delhi High Court as well, we were also parties in that case. The Delhi High Court had also posed this question before the government, that you have not formulated the new industrial tribunals under the code. So what now? What are we supposed to now follow? And the government came up with a very interesting clarification. The government stated that, interestingly, we have not repealed the old laws yet. So at that point in time, the Industrial Disputes Act was not repealed at all. That is what the central government said before the Delhi High Court. In order to solve this problem, they had issued a clarification or a difficulties removing order, as we say legally. Now, what that order stated, that even though the Industrial Disputes Act has not been repealed yet, but the old cases will still continue before the industrial tribunals and the labor courts, which are still existing. Then came another difficulties removal order and another notification. Now that notification stated that now we are repealing the Industrial Disputes Act and the other laws, but we are doing it retrospectively from 21st November 2025 onwards. So what then happened was that even though these laws were repealed retrospectively, but still the existing industrial tribunals and the labor courts were still continuing, right? So the difficulties removal order basically stated that both the old matters will continue before the existing industrial tribunals and the labor courts, but the new matters as well, they can come before the old forums and the industrial adjudicators as well. So the current position is really this, that both the old cases and the new cases will come before the industrial tribunals and the labor courts as are existing currently. Interestingly and paradoxically, there have been a few judgments, one of the Madras High Court and other of the Karnataka High Court, if I'm not wrong. Now, the court very interestingly said that even today references can be made by the appropriate government and the reference can be made to the industrial tribunals or the labor courts. Now, even though the difficult, and there was an amendment to the IR code recently as well, which had basically amalgamated these difficulty removal orders, and they had made an amendment stating that the existing tribunals and labor courts will continue till such time the new tribunals are not formulated by this or constituted by this by the governments, and that till the time this does not happen, both the old cases and the new cases will continue before the or come up before the existing labor courts and industrial tribunals. So the amendment has sought to codify this. Now what had happened was that the Karnataka High Court had held that that a reference order can be passed by the appropriate government, and that reference can now be made to the existing labor courts and industrial tribunals as well. Even though it is quite secular that the old authorities will continue, because even the existing conciliation office, etc., all the authorities are still continuing. But that will still not mean that references can be made, because the old law has been repealed and the new law has come in place. So the question of making references, in my opinion at least, out of question. Next slide, please. So, as I said earlier as well, the rules have not come into force. Obviously, the central rules have come into force, but the state rules are yet to come in. So there are certain provisions which you will have to comply with immediately, because their existence and their implementation is really not dependent upon the rules. They exist separately, and their implementation will have to be done regardless of the existence of the rules. So you have compliance with the substantive provisions, payment of wages within 2 days, display of abstracts. Gratuity is to no longer be paid on basic plus DA, but as per the new definition of wages. Interestingly, there was a judgment of the Supreme Court back in the day with respect to the Payment of Gratuity Act, wherein the Supreme Court had held that the definition of wages under the Gratuity Act is quite similar to the definition of wages under the EPF Act. So if we were to see this legally, even under the old law, you had to deposit your gratuity payments as not only on basic and DA, but on other allowance as well. That is the allowances that were being paid universally, ordinarily, and necessarily. But we all know that no one was doing that, even though that was, the legally tenable position. But it really does not matter because that was the custom, and now, as it is, the Payment of Gratuity Act has been repealed. Other imperative mandates such as benefits commensurate to those being provided by the permanent employees are to be paid to the FTs. PF and ESI benefits are to be contributed. Working hours, leaves, etc., wage slips. All of this will have to be done now only, and it is not dependent upon the rules. Next slide. Yes, so let us now come on to the important definitions. The definition of appropriate government assumes importance not only for the purposes of raising or the pendency of industrial disputes, but from other perspectives as well. So the Industrial Relations Code obviously says that if an industrial dispute is pending and the workers have arraigned both the principal employer and the contractor as well, and for the principal employer the appropriate government is the central government, then for the contractor the appropriate government will be the central government as well, even though you are not really, you do not function under the authority of the central government, or you are not a public sector undertaking, etc. But for you, even otherwise, the appropriate government will be the central government only. And I think that the code which offers a little bit of variance in that regard is the Code on Social Security. Because the Code on Social Security basically says that even if I do not fall under the ambit of the central government, that is I'm not a public sector undertaking, or if I'm not controlled by the central government, even then, for me, the appropriate government will be the central government if I have branches in more than one state. So if I have branches in more than one state, then the appropriate government for me will be the central government, at least under the Code on Social Security. I think that one more issue which loosely relates to the concept of appropriate government is that of jurisdiction and exclusive jurisdiction clauses. Nowadays, there is this, there is this practice that a lot of employers are following, is that in the appointment letters or in contracts of engagement, they incorporate an exclusive jurisdiction clause. Now, that exclusive jurisdiction clause reads like this, that you can raise a dispute or you can file any case before the company in this state only or before the courts of this state, so whether it be Hyderabad, Bombay, Delhi, etc. Now, obviously, if an employee decides to file a civil suit against you, then these clauses are very well enforceable. But what if he is working, say, in the state of Hyderabad, but I have only one head office and it is located in Mumbai, and the exclusive jurisdiction clause says that you can only raise a dispute in Mumbai? Will he then, be liable to raise an industrial dispute in Hyderabad or in Telangana? I mean, the answer is not quite clear today because there's a variance of opinion. The Madhya Pradesh and the Calcutta High Courts have held that, he can raise an industrial dispute anywhere so long as that state has some nexus with his employment. So if my status of employment is there or control and supervision is exercised from there, then I can raise an industrial dispute there. But if there's no nexus, you cannot stop me. Now, what had happened is that the Bombay High Court in a recent judgment had held that this principle which governs civil cases, or which is a principle which was formulated under the Civil Procedure Code, because exclusive jurisdiction clauses it is basically a function of civil codes or civil cases. The Bombay High Court has held that this principle can be imported to industrial disputes as well. So this is something that probably the courts will adjudicate upon or develop as we go along. Next definition. So the definition of worker assumes a lot of significance because leave-related provisions or the working hour-related provisions under the OSH code are only applicable with respect to workers. The IR code as a whole also is applicable only with respect to workers and not employees. So it is imperative for you to determine as to which of your employees is a worker and which employee is really an employee, that he is performing duties which are predominantly managerial or supervisory in nature. Now you'll see that the definition provides you with certain categories: manual, skilled, unskilled, technical, operational, clerical, supervisory, etc. Now there was this very famous judgment of the Supreme Court in HR Adhyanta. What that judgment said is that if there is an employee and he does not fall under the ambit of any of these categories, then he is not a worker. Even though he may not be performing work which is majorly supervisory or managerial in nature, he would still not be a worker. And the court gave the example of a sales promotion employee. Of course, that example will no longer apply because the court has directly made sales promotion employees and working journalists workers. Of course, there was the sales promotion employees of 1976, which was an earlier law, and it has been subsumed by the OSH code. That also had contained a deeming provision. It was section 6 subsection 2, if I'm not wrong, by virtue of which the Industrial Disputes Act was applicable to the sales promotion employees as well. But now directly by the ambit, by the virtue of this definition, these persons are workers. But for you, essentially the exercise would be to determine as to whether these persons are performing work which is predominantly managerial and supervisory in nature. And you know, that is something that does not easily, it is a very difficult and daunting task, because merely on the basis of your designation, even if a person is designated as a manager or supervisor, you cannot ipso facto say that he is not a worker or that he is performing managerial or supervisory tasks. You will have to determine his predominant nature of duties. So if there is a person who is supervising a group of people, he can sanction leaves, he can sanction overtime, he can write reports, he can, recommend leaves, etc. Then obviously he would be a supervisor. But that will have to be determined on the facts and circumstances of each case. Interestingly, there was a judgment of the Supreme Court wherein the Supreme Court held that even if an individual is supervising a small group of people, say 2 or 3 people, even then he would not be a supervisor per se, because it depends upon the structure of the organization and what the number of people working there and how many people are usually working under one supervisor, etc. Then there is another aspect to this as well. There have been various judgments, both of the Supreme Court and the High Courts, which have held that, if there is a person who is performing managerial tasks, then that what encompasses that managerial task will have to be determined on the basis of the actual worksheets that you offer to your employee. So if in your appointment letter you have stated that you will be performing managerial tasks or managerial work, that obviously cannot determine if he is performing managerial work. You'll have to produce evidence if a matter is pending before the industrial tribunal and the worker has contended that I am not a manager, then the burden is upon you as the employer to show that he is indeed a manager, and you'll have to produce documents and perhaps leave sanction reports or leave slips, etc., to show that he is indeed a manager or a supervisor and that he is performing such works. Next slide. Now the definition of employee and worker is mostly similar, except the fact that people who are performing work which is predominantly managerial and supervisory in nature will fall under the definition of employee as well. So the only difference majorly is that employees will perform managerial and supervisory work, while workers will not perform supervisory and managerial work. Of course, a worker can perform supervisory work as well, provided that he is drawing a salary of less than 18,000 rupees. This is where the main distinction lies. But for the purposes of ensuring that your workflows move in a positive direction, it would be imperative for you to draw a distinction, and that distinction has to be formal, right? Next slide. Now, the definition of employer, interestingly, has been borrowed, the first part of the definition at least, has been borrowed from the Minimum Wages Act. Because what the definition essentially says is that employer means a person who employs, whether directly or through any other person or on his behalf, any person, one or more employees or workers, etc. So, what this essentially means that even though I am the employer of a working under me, I am also the employer of a person who is employed through a third party agency or a contractor. Now, this obviously can have wide implications, because under the existing laws as well, various high courts and the Supreme Court have given judicial pronouncements that as principal employer, I am liable to pay PF contributions, ESI contributions, minimum wages, etc. of the workers of the contractor in case the contractor defaults. Now, but for other purposes as well, this definition will kick in. For instance, under the earlier law, if the contractor's workers had raised an industrial dispute against me, then the workers had to show either that the contract was sham or camouflage, or the workers had to show that the permanent employees of the employer were also substantially interested in that industrial dispute. But now, because of the new definition of employer, for the purposes of this code, because what the code does is that it creates a deeming fiction, and this deeming fiction is similar to what was there under the Factories Act as well, because the definition of worker under the Factories Act had also stated that worker is both a person who is employed directly by the employer as well as by the contractor. So deeming fiction is created by the code by the code for the purposes of the code, and an industrial dispute can now be perhaps raised against you as the principal employer, even if there is no espousal, or even if the persons are not, the direct employees are not directly interested in the dispute. So this is a very interesting facet of the code. Next, please. The definition of contract labor, the first part of it at least, remains the same. It says that workers hired in or in connection with the work of an establishment or principal employer by or through contractor, with or without the knowledge of the principal employer, would be a contract laborer. Now, what is imperative for us to note here is that it says hired in or in connection with the work of the principal employer. Now, we tend to have this habit that as soon as we engage a third party vendor or third party, whatever, contractor, we assume that that arrangement falls under the ambit of the contract labor regulation and abolition regime, and we quickly go on to obtain licenses and registrations. But that is not always the case, because what the definition essentially says is that this person should be hired in or in connection with my establishment as the principal employer. What this means, and this has been interpreted by two high courts, the Odisha High Court as well as the Delhi High Court. What both the high courts have held, that if this person was not solely hired for my establishment as the principal employer, then he would not fall under the ambit of the definition of contract labor. For instance, if there's a worker who is working in your establishment as a contract labor, he is engaged through a third party vendor. Now, the appointment letter which the third party vendor issues to him says that the services are transferable, and at any point in time your services can be transferred from this establishment to that establishment. Then the high courts have felt that this arrangement does not fall under the ambit of the contract labor arrangement, because again, he was not hired in or in connection with my establishment of work as the principal employer. And this philosophy in many ways has been taken forward by the labor codes as well. So you'll have a look at the second part of the definition. It says that a worker, other than a part-time employee who is regularly employed by the contractor for any activity of his establishment, his work employment is governed by mutually accepted standards, and he is paid some periodical increments and is covered by social security arrangements. So this individual, the contract laborer, under the codes, if he performs some work for the contractor's establishment as well, or for any other establishment as well, and he is issued an appointment letter, he is paid increments, or he is covered under the ambit of social security arrangements such as ESI, PF, etc., then he will not be regarded as a contract laborer. But it is imperative for him to receive certain periodical increments as well. Now, if I'm not wrong, the central government in its rules has capped this increment at 2% of the annual salary of the contract laborer. Of course, the state rules can prescribe a different threshold, but the fact remains that if this person is also an employee of the contractor, such that he performs some work for the contractor, and for other establishments as well, then you need not register this arrangement for the purposes of the contract labor regime. Next. As I stated, that a permanent employee of the contractor getting benefits under labor laws will no longer be considered as a contract laborer. Even though this was earlier the position as well, this has been fructified and codified by the labor codes. Next. Can you please go one step? Yeah. So, the definition of contractor also again reiterates this concept. It also says contractor in relation to an establishment. So any contract labor arrangement can only work in relation to an establishment, and the establishment is always that of the principal employer. So if the work is in relation to my establishment as the principal employer only, then only the arrangement will come under the ambit of contract labor. Next. So I've already talked about this. Next. Right. So the quandary around core activities. Now the code obviously says that if there is a core activity, then you are not, as the principal employer, allowed to engage contract laborers for the purposes of that core activity of your establishment. Of course, there were similar provisions in your state, that is Telangana and Andhra Pradesh. The state government had amended the contract labor regulation and abolition act to state that if the contract labor is performing any core activities, then that is not permissible. Now the definition of core activity says that a core activity will be one which is for which your establishment has been set up and which is essential to your establishment as well. Now that statement alone is quite sweeping in its own right, because I mean, if you look at it pragmatically, every activity that you are carrying in your establishment is at the end of the day essential to your work only. But the silver lining is that a lot of activities have been excluded from its ambit, for which people usually deploy contract labor, such as say sweeping, housekeeping, nursing, transport, etc. So that is obviously a good thing. There's one more question that I keep on getting asked, is that what if we accidentally or for any other purpose, good or bad reason, we had engaged contract labor in one of our core activities. Now does that ipso facto automatically mean that these contract laborers will become our employees as the principal employer? The answer is a clear no. So under the old laws, the Supreme Court, so there was a section 10 under the Contract Labor Regulation and Abolition Act, which had stated that it was the discretion of the appropriate government to say that this kind of work or this activity is now abolished and contract laborers cannot be engaged for this purpose. Now what the code does is that it automatically puts a prohibition. It says that you cannot engage in your core activities at all. Now with respect to abolition of contract labor, the Supreme Court in a catena of judgments such as that of Steel Authority of India, etc., so on and so forth, had held that even though you are engaging obviously you cannot do that, that may be a punishable offense, but that ipso facto does not mean that these persons will become your employees. For them to become your employees, they will have to lead positive evidence before the industrial tribunal or the industrial adjudicator that the contract was sham, ruse and camouflage. If they are able to show that, only then and only then they will be your employees. Next slide please. Now there are certain exceptions to this, right? Even though as a general rule of thumb you cannot engage contract laborers in the core activity of your establishment, but there are 3 exceptions. The first exception being that the normal functioning of your establishment is such that the activity is ordinarily carried out through the contractor. I mean, if I were to percolate this exception, it basically means that this activity was being carried out in my establishment since time immemorial, or that it was perennial in nature and that it was ordinarily being carried out. Now various tests had been laid down by the Supreme Court and various high courts for determining as to whether an activity would be perennial or not. Now if an activity is perennial, if it was being carried out since some time, 3, 4, 5 or 6 years. So if I am able to prove it before the labor authority or whatever authority has been designated by your state rules for determining whether the activity is core or not. If I'm able to show that before the authority that this activity was being carried out in my establishment by contract laborers before the coming of the code and quite some time has passed since, right, then I will have the leeway of still engaging these people in my establishment even though the activity that they are performing is a core activity. Now there are other exceptions as well, but their applicability is really a dime a dozen, because there would seldom be an activity for which you will not require full-time employees or for which you will not require them to work for most part of the day. And of course, if there's a sudden increase of work or workload in your establishment, then also you can engage contract laborers in the core activities of your establishment. Next. So I have already discussed all this, so I'll be moving ahead. Next. 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 Right. Coming on to fixed term employment now. There were many people who were of the opinion that this concept of fixed term employment has been introduced under the codes for the first time, but that could not be farther away from the truth. Because you had the model standing orders that were issued by the central government under the erstwhile legislation. They had also defined fixed term employees, who was a fixed term employee and under what circumstances can he or she be engaged by you. Now, for a person to be a fixed term employee, obviously, there are majorly two prerequisites only. Firstly, that they are issued a contract of employment or an appointment letter, and secondly, they are engaged for a fixed term period or for a short period, right? But there are certain other prerequisites as well. So if I am employing a fixed term employee, then firstly, I'll need to provide them benefits commensurate to the permanent employees if they are performing work which is same or of similar nature as that of the permanent employee. And there were many people who were asking this question as to what would happen if I engage fixed term employees in a core activity of mine. So the code does not prohibit you from engaging fixed term employees in core activities, unlike contract laborers. In fact, it encourages you to do that, because it itself says that if there is a fixed term working arrangement and your permanent employees are also carrying out work which is of same or similar nature, that is, perhaps it would be a core activity of yours and me as well. So that work, if they are carrying out that work, then the benefits that you provide to them, whether it be leaves, any other benefit, then that would have to be commensurate with the permanent employees as well. So I'll give you an example. If you are paying, say, a bonus amount or an ex gratia amount monthly, yearly, or annually to your permanent employees, since a very long period of time, it becomes a condition of employment for your permanent employees, because you are doing that for a very long period of time. Now, when you engage a fixed term employee for that work, it automatically, becomes their part of employment as well, because it is a part of employment or an employment condition of the permanent employees as well. So now you'll have to pay that ex gratia amount or bonus amount to your fixed term employees as well. Then again, the second proviso says that if there's a fixed term employee and he has not, he's not eligible, or he has not completed or has become entitled to certain provision, a statutory right, then that right will have to be provided to them regardless. I'll give you an example. So under the OSH code, it is imperative for all employees to complete at least 180 days in a calendar year for them to be entitled to leaves, which is a 1 day of work for every 1 day of leave for every 20 days of work. Now, if there's a fixed term employee, his employment is ending, say, after 3 months in a calendar year, he would still be entitled to those benefits, even though he has not completed 180 days of work. Then obviously there is this aspect of gratuity. Under the Code on Social Security, it has been stated that fixed term employees are entitled to gratuity, albeit on a pro rata basis. Now, the Industrial Relations Code qualifies it by stating that a fixed term employee is only entitled to gratuity if he completes 1 year of service. The central rules under the Code on Social Security also reiterate that. Now, interestingly, it only says that gratuity will have to be paid when a fixed term employee completes 1 year of service. It does not in any manner of form says 1 year of 1 year of continuous service, because the term continuous service was defined at least under the erstwhile act, that is the Payment of Gratuity Act 1972, under section 2A. Now it had stated that, firstly, continuous service would be there when a person has completed work without unauthorized leaves, etc., so on and so forth, and even if he has completed 240 days of service in the alternative. This does not say that continuous service of 1 year is required. So would that mean that in the entirety of 365 days will have to be taken into consideration for that? Will leaves be counted? Will leaves not be counted? Will unauthorized absence be counted? This is something that will have to be clarified by the government. Next, please. So I've already talked about this, but just to give you some clarity on this aspect, there were many people who were saying that if I keep on engaging fixed term employees for years together, or if I renew their contracts year after year, say 4, 5, 6, 7, 8 years, then would they be entitled to regularization with me? The answer to this again is no. They would not be entitled to regularization. But then if you decide to terminate them, they would be entitled to retrenchment compensation. Because if you keep on re-engaging fixed-term employees for years together, their work is as good as permanent employees. And the Supreme Court, with respect to Section 25F of the erstwhile Industrial Disputes Act, had held that if I keep on engaging fixed-term employees for years altogether, then firstly, that is an unfair labor practice. And if it is an unfair labor practice, obviously it would be a violation of Section 25F. So it would be better for you to pay them the retrenchment compensation and the notice pay at the time of your termination, so that you do not have to face prolonged litigation at the end of the day. Next, please. So I've discussed all of this. Next. Right. So, on the aspect of leaves, even though this will be covered in detail by Mr. Govind Raju, I'll just touch upon it peripherally. Now, obviously, only people who fall under the definition of worker under the OSH code will be entitled to the leave-related provisions under the OSH code. So, for every 180 days, if I'm able to complete 180 days in a calendar year, then for every 20 days of work, I will be entitled to 1 day of leave. And interestingly, this is for the first time, because I'm sure that the Telangana Shops and Establishments Act does say that I'm entitled to leave encashment even during the subsistence of my employment. Please correct me if I'm wrong. The Telangana Shops and Establishments Act does say that. I think the limit is somewhere around 10 or 20 leaves I'm able to encash during the subsistence of my employment in a single calendar year. 8 days. Right, 8 days. Under the Telangana Shops and Establishments Act. Now, and Andhra Pradesh as well. Right. So, what the code essentially says is that I can encash leaves during the subsistence of my employment under 2 circumstances. The first is on my discretion at the end of the calendar year, I can do that. But secondly, when my leave carry forward exceeds 30 days in a year. When my leave carry forward exceeds 30 days in a year, then the employer will mandatorily have to encash the excess amount and he will have to pay it to me. So there are only 2 circumstances under which leave encashment can be done during the subsistence of my employment. Obviously, at the end of your employment, you will be entitled to leave encashment. But the problem arises when these provisions are not in consonance with the Shops and Establishments Act. Because Shops and Establishments Act of one state may say that I am entitled to 18, 20, 25 leaves in a single year. Now the code majorly says that I am entitled to roughly around 15 leaves in a year. If we calculated 180 days in a calendar year and 1 day of leave per 20 days of work, then it would come to roughly around 15 leaves in a year. But then the Shops and Establishments Acts of majority of the states do not provide leave encashment during the subsistence of employment. Telangana has Many of you very rightly said that I can encash 8 leaves in a single calendar year. The code obviously does not place a limit in that regard. So the provisions of which enactment, whether the central code or the State Shops and Establishments Act, would be beneficial for me. Can we move to the next slide, please? Next. Yep. So there is one section 120 under the OSH code. Now this section provides that if I am entitled to better terms and conditions under any statute, terms or conditions, policy, etc., then that will prevail over the code. Now it says with respect to matters. Now leave in itself is a matter. The question is, can a single matter be bifurcated into sub-matters? That will have to be decided by the courts only. There was an interesting judgment of the Supreme Court with respect to the Payment of Gratuity Act, wherein the employer had his own gratuity scheme, which was in some respects better to the Payment of Gratuity Act, but in some respects it was not. Now the Payment of Gratuity Act, on the other hand, existed in silos. The question was which one of it would prevail, and can the employees avail both benefits in bits and pieces? The Supreme Court was no, but the Supreme Court held that no, you cannot do that. You can either avail the benefits under the scheme as a whole, or you can avail the benefits under the Payment of Gratuity Act as a whole. You cannot have your cake and eat it too at the end of the day. So whether the Supreme Court or the High Courts will adopt this line of reasoning or not remains to be seen. Next slide, please. Next slide. Next. So I have created a compilation of what happened when there was some sort of divergence between the provisions of central laws and the Shops and Establishments Act. So one judgment had held that, in one judgment the Supreme Court had held that the state law would prevail when it was more favorable. In another judgment it was held that the central law would prevail. But in certain judgments the court had also held that when there is no repugnancy and when both can be taken along, or can be interpreted in a harmonious manner, then it would be better for you to interpret both in a manner such that the state legislation is not repealed. So this is known as the doctrine of implied repeal, that when there is a central legislation and when there is a state legislation as well, and the provisions are not in consonance with one another, the state legislation would be deemed to be repealed. Now whether that would happen would depend upon the facts and circumstances of each case. Next. So the definition of industry has seen a sea of change insofar as semantics is concerned. The first part of the definition is although different from the bare language of the statute, bare language of the definition as it had existed way back. But the first part of the definition very closely resembles the judicial dicta in the Bangalore water supply judgment as given by Justice V.R. Krishna Iyer. So there has to be a systematic activity. And when there is a systematic activity, it has to be with the cooperation between the employers and the employer, and necessarily there has to be some production of material goods, products or services. Interestingly now, charitable organizations have been excluded altogether. If one were to go through or read the Bangalore water supply judgment, the court had very clearly held that charitable organizations per se would not be excluded from the ambit of industries. Only if the organization or the charitable organization was carrying out charitable works, charitable works in the sense that it had engaged volunteers and not employees per se, or so to speak, then it would not be industry. But if I was carrying out charitable activities and I was engaging normal employees who were carrying out works as they carry out works in any commercial establishment or general establishment, then it would still be an industry. Now, this definition simply says that charitable organizations or philanthropical organizations would not be industry. Whether the judgment of Bangalore water supply would then come into play, something that will, we will see. Because the Bangalore water supply judgment, as you all know, is still under challenge. There was a 9-judge bench which was reconsidering the judgment of Bangalore water supply. and that matter has now been reserved, and the Supreme Court will give its pronouncement in days to come. Next. The judgment of the definition of industrial dispute largely remains the same. It is just that the government has combined the definition so as to include both industrial disputes and individual disputes in a single definition. As I said earlier as well, in collective disputes, the workers have to provide an espousal. So an espousal is basically a proposal wherein large number of workers of your organization or a union, they express their intention of raising an industrial dispute against you. Now, of course, that is not imperative with respect to individual disputes, because an individual dispute can be raised single-handedly by an employee, by a worker. Even if I do not have the support of a union or the majority of my employees, still an industrial dispute would hold, if it is with respect to termination or retrenchment, etc. So the definition, therefore, largely remains the same. Next. So the definition of retrenchment also remains the same, except the fact now they have added another exception. Now that exception says that if the termination of my services are as a result of completion of tenure or fixed term employment, then that also would not be retrenchment. If you have a look at the subclause above that, it also reiterates the same thing. It says that if my employment comes to an end by virtue of a clause or a stipulation contained therein, that my employment is for a fixed term period or for a short period or a temporary period, and if it comes to end, then obviously that would not be retrenchment because it was a part of my conditions of service. One interesting thing to note here is that termination of services of a worker on ground of continued ill health is also not retrenchment. But if you'll have a look at the judgments rendered by the Supreme Court and various high courts in that regard, you'll find that proving this is a very difficult task. Right. So proving that itself is a very precarious task, because not only will you have to show medical documents or medical reports of your doctor, the company doctor, but you will also have to engage an independent medical practitioner. That independent medical practitioner's report should also be able to show that this person was suffering from continued ill health. Next. So I have been informed by the organizers that I only have 10-20 minutes left, so I'll just be parsing over through these definitions. The definition of settlement is not that important, so I'll be going ahead. The definition of strike remains the same, except the fact that now, even if persons engage in concerted casual leaves, and the persons who engage in such concerted casual leaves exceed 50% of your total workforce, that will also be a strike. Now, interestingly, the code does not define as to what a casual leave stands for. Of course, casual leaves you all understand, and we are able to interpret as per the definition provided under the Shops and Establishments Act. But what it means under the code and as to what the legislature meant by casual leave is something that will have to be determined. Even the standing orders state what a casual leave is, but because many a times employees take casual leaves for holidays as well. So 50% or more of my employees take a casual leave in lieu of a holiday. Will that be a strike? This is something that will have to be determined by the judiciary. Next. Coming on to the linchpin of the codes is the definition of wages. So I have prepared a comparative analysis between the old laws and the new definition of wages. The parts which is highlighted in black is synonymous to the definition of wages under the under the labor codes as well. So the black part is similar to that of the definition. So you can see that they have adopted the definition of wages under the codes, and they have taken bits and pieces from the old laws as well. So it is not that the definition is totally novel. And if you'll have a look at the Minimum Wages Act and the Payment of Wages Act, the first part of that definition is quite similar to the definition of wages under the code. So I'll move ahead. Next. Next. So the definition of wages starts by stating that wages is all remuneration. So remuneration is basically any payments that you make to your employees, any recompense, any and all payments that you make to your employees. Now obviously, any and all payments that you make to your employees, simpliciter cannot be wages. That is why the first part of the definition then goes on to qualify the term remuneration. So even though you are paying remuneration to your workers, that remuneration has to be paid under the terms of your employment or under the terms of the contract. Now, if it is paid under the terms of employment or under the terms of the contract, there can exist three situations. Firstly, if that amount is mentioned in the appointment letter itself. Secondly, if that amount is mentioned under the terms of your employment, whether it be standing orders, service rules, etc. Third, if it has become an implied condition of service. Now, any amount becomes an implied condition of service when it is paid for a long period of time and in an unbroken manner. So, if I have been paying ex gratia payments or bonuses to my employees every year, year on year, and there was no break in between, that becomes a condition of service and that would automatically be wages. Now, wages include salaries, allowances, or otherwise. So that the term remuneration and salary is mostly similar because salary is any payment that you pay to your employees for the work that they have done. Allowances are also payments that are given for a specific purpose. The term otherwise perhaps would mean payments that are made which may include remuneration in kind, which is why the definition later goes on to say salaries, allowances or otherwise payable and whether expressible in terms of money or not. So even remuneration in kind, which may include Sodexo meal coupons, fuels, car reimbursements, etc. They may also be remuneration in kind, and this has been clarified by the central government in its FAQs as well. And then this brings me to this very pertinent question of whether your incentives would be wages or not. So the Ministry of Labour and Employment in its FAQs has stated that incentives which are being paid in an annual fashion would not be wages. But as per me, this is not always the case, and I'll show you why. Can we move to the next slide? Next slide, please. Next slide. Next slide. Right, so I have prepared a list of illustrations. Now, obviously, these illustrations are in respect of the judgments that were rendered by the Supreme Court and various high courts with respect to the earlier laws. But as I stated, that the first part of the definition under the ESI Act, obviously that part which says that, which gives a rider of 2 months that if it is paid beyond 2 months, it is not wages. That part obviously I'm not referring to. But the first part of the definition, the Minimum Wages Act, the Payment of Wages Act and the ESI Act is really synonymous, to that of the code itself. And in various judgments, the Supreme Court and various high courts had gone on to the extent of holding that even incentives or ex gratia payments would be wages. But they would be wages only when they're mentioned in your terms of employment or your contract of employment. There was a very interesting case wherein ex gratia payments and bonus amounts were being paid to employees since a long period of time as per a policy. Now that policy itself had stated that this policy can be withdrawn at any point in time and it is not compulsory for the management to pay you increments or ex gratia payments or whatever. Now the Supreme Court had held that because your policy itself stated that this policy can be withdrawn at any point in time, and this policy was also shared with the employees. Therefore, these payments would not be wages. But if you are continuously paying increments, etc., to your employees without any policy, and without the policy itself stating that these payments can be withdrawn at any point in time, then definitely such increments would form part of wages. Next. Now, coming on to the exclusions. Next, please. Next. Right. Coming on to the exclusions. The first exclusion says that any bonus payable under any law which does not form part of your conditions of employment would not be wages. I think this would perhaps only include your statutory bonus because it is paid as per provisions of law and it obviously does not form part of your conditions of employment. Then you have any value of house accommodation, etc. This exception does not hold much value because under this exception, amounts will have to be notified by the central government itself. Only then it would be an exclusion. Then your conveyance allowance or travel concession, obviously this is quite simple and straightforward. So any conveyance allowance that you pay to your employees and even LT, etc. that you pay to your employees would be an exclusion. Next. Now any sum paid to the employees or persons to defray special expenses entailed upon him by the nature of your employment. So these amounts are basically reimbursements that you pay to your employees for the special expenses that they have incurred while performing their work. So I've given certain illustrations again, and these judgments were rendered with respect to the previous laws. Even though they were rendered with respect to the previous laws, a similar exception was contained therein as well. So in my opinion, these case laws will continue to remain applicable. Next, please. Next. I'll come straight to the bone of contention, which is the first proviso. Next. Next. Next, please. Right. So the first proviso basically states that if there are exclusions which I am paying, and those exclusions exceed 50% of the all remuneration that I am paying to my employees, then the excess portion will be deemed as remuneration again and will be part of wages. Now, this definition itself can be interpreted in two different manners. The first is obviously the interpretation which majority of the stakeholders are following. That the term all remuneration means all payments that I am paying to my employees as per the terms and conditions of employment. I'll do 50% of that. And if my exclusions exceed that amount, then that would be remuneration and that would be wages. Now, can we move to the next slide, please? So this is an illustration which was issued by the central government. And you will be able to see, even after a bare analysis of this illustration, that the central government is following the first interpretation. So it is taking 50% of all remuneration or all payments that I am making to my employees, and then if the exclusions exceed that amount, then the excess will be deemed as wages. Next slide, please. So this is the second illustration. This was issued in the FAQs itself. This also follows the first interpretation itself. But then there's another interpretation. Because subclauses A to I are exclusions, if you say that they are not remuneration in the first place, then they cannot. Then can they be deemed to be remuneration, because it says that these amounts will be deemed to be remuneration. So if they are remuneration in the first place, then you will not calculate 50% of them. Only the inclusions then will be halved. And if the amount exceeds 50% of the inclusions, then it would be deemed as remuneration, because these exclusions are not remuneration in the first place. Now, if they were remuneration or not remuneration, you would not have said in the first proviso that they would be deemed to be remuneration. Next slide, please. Next. So these are previous, please. Please move on to the previous slide. So these are certain illustrations that I have prepared with respect to both the interpretations. So as per the first interpretation in this case, the exclusions amount is not exceeding 50% of all remuneration. But if we move on to the second illustration, can you please go to the next slide? Herein, with respect to the same amounts, it is exceeding 50% of all remuneration if I were to take all remuneration as the inclusions only. So we never know which interpretation the courts might favor, because if we go by the second interpretation, that interpretation is more favorable for the employees. So there are chances that the court might adopt the second interpretation. This is next slide, please. This is the second illustration. Again, herein as well, I have taken into consideration both the interpretations. If I were to follow the first interpretation, the 50% amount would not be breached. If I were to follow the second the second interpretation, the 50% amount would be breached. Next slide, please. Next slide. Right. So the possibility of splitting minimum wages, this question of course has been posed to me a lot of times now, as to whether minimum wages can now be split into various allowances. And the answer to that again is a clear yes. Obviously, you will not be able to split minimum wages amongst your exclusions, because exclusions obviously would not form part of wages. But if I have a basic component in my salary and a special allowance or other allowance component, which by the virtue of it being part of my terms of employment or conditions of service, it is part of the inclusions as well. So there is no harm in me splitting my minimum wages between the basic pay amount or any other allowance which forms part of my conditions of service. Next, please. The question of restructuring, because many companies are nowadays going ahead and restructuring their salaries almost in a wanton manner. Now, perhaps the only impediment that is placed upon the companies prohibiting them from restructuring their salaries would be Section 124. And just before I discuss Section 124, let me also clear this misconception. Many people say that it is now a statutory mandate for us to restructure our salaries such that our inclusions are 50% of the total remuneration. That is obviously not the case again, because the first proviso merely creates a deeming provision. It merely states that the excess amount will be deemed to be remuneration. It does not tell you to restructure a salary such that your inclusions are 50% of the total remuneration, because that would really be circular logic. Because as it is your exclusions are exceeding your 50% amount, they're deemed to be inclusions. Now you will be taking that excess amount and will be placing it to the inclusions again. So that would be circular logic only, because again they would be inclusions only. Earlier they were also inclusions by virtue of the deeming fiction. Now on the aspect of restructuring, Section 124, obviously this would be dealt in great detail by Sri S.K. Gupta as well, because he would be taking the session on the Code on Social Security. Now, Section 124 basically states that if you are reducing the wages or the total quantum of benefits so as to evade the payment of ESI or PF benefits or contributions or any other charges, or to reduce such contributions, then that would be illegal. Now, what a lot of people nowadays are doing is that, say for instance, my salary is rupees 25,000. Now 20,000 is my basic pay and 5,000 is my HRA, right? So my total is rupees 25,000. Basic is 20,000. HRA is obviously an exclusion. So obviously this person would now be covered under ESI because 20,000 is below the threshold of 21,000. A lot of people are now from the HRA component are taking 2,000 or 3,000 rupees and they're transferring it to the basic pay amount, such that now my basic pay amount is 23,000 out of 25,000. The question is whether such restructuring is legal or not. And the answer would again be a clear no. Because Section 124 itself says that you cannot reduce your wages or any other total quantum of benefit such that so as to evade the payment of contributions of ESI and EPF. Here, not only are you reducing your EPF and your ESI contributions, but you are evading. This is a deliberate act of evasion. This is a device. So that obviously would not be taken too kindly by the ESI authorities. They might pose to you this question as to why you restructure your salary after the advent of the labor codes, because you could have done that earlier as well. So it shows your intention as well that you carried out such restructuring exercise purposefully so as to reduce your gratuity and ESI liabilities. Next. So these are certain questions that you will need to take into consideration while you are restructuring your wages. is my company directly reducing the wages of the employees? Are you doing it indirectly? Are you reducing the components, the total quantum of benefits? If the answer to any of these questions is yes, then that restructuring would be illegal from the very get-go. Next. So I'll just be moving quickly now because I do not have a lot of time left in my hand. So Works Committee, nowadays what is happening is that earlier what used to happen is that is that in industries which was riddled by industrial unpeace, the central government or the state government used to issue notifications stating that you need to formulate works committees. But nowadays such situations are a few and far between. So you will need to constitute a work committee only when there's a notification or a special or a general order issued by your appropriate government in that regard. Only then and only then will you need to formulate a works committee. Otherwise you need not formulate it. Next. Coming on to the provisions pertaining to the grievance redressal committees. Now under section 9C of the erstwhile law, that is the Industrial Disputes Act of 1947, even though it was mandatory for you to formulate a grievance redressal committee, it was not actually a mandate and it was not being followed practically, because even if you had an internal grievance redressal system, then it was not mandatory for you to form a grievance redressal committee. Now, even if you have an internal grievance redressal policy or mechanism in place, even then you will have to formulate a grievance redressal committee. Next slide, please. So, as I said, that constitution of a grievance redressal committee is mandatory. But what the code essentially says is that you can even have more than one grievance redressal committee per your industrial establishment. And this is because the definition of industrial establishment is such that it includes an industrial establishment or industrial undertaking. Now, there have been various judgments of the Supreme Court, including that of Indian Express, wherein they have held that an industrial establishment itself is severable. So, within one establishment, there may be several other undertakings or establishments. So, if you have various departments which are performing works which are very different from the work of a different establishment, then perhaps you need to formulate more than one grievance redressal committee in your establishment. And the tenure of your grievance redressal committee would be that of 3 years. But interestingly, this grievance redressal committee can only deal with individual disputes. So a group of employees cannot come up to me and say that, we have this dispute or you need to pay us increments or whatever, and that now you'll have to admit our dispute in the grievance redressal committee. That is not mandatory. But then again, there are chances of subterfuge as well, because it takes no time from an individual dispute to formulate into a collective dispute. It happens really quickly nowadays. Next. So, so the maximum size of the grievance redressal committee can be 10 workers, and out of these 10 workers, at least 5 should be that of the workers. So it has to be equal. 5 representatives of the workers, 5 representatives of the management, and there will be a rotating chair. So the chairperson of the grievance redressal committee 1 year would be that of the management, the second year would be that of the workers. Obviously, women representation has to be proportional. So if I have, say, 100 women employees in my establishment, then out of the 10 workers, a proportional representation would have to be given to the women workers as well. Next slide. So from the employer's side, you'll have to choose the employer's representatives as per your own volition. It is completely in your hand, the number of the members that you wish to engage, but the only condition is that these members should form a part of the management. The second one is that which members are to be chosen from the workers' side. So if you have a negotiating union or a negotiating council, etc., obviously they can nominate workers, but if you do not have a negotiating council or a union, etc., then the workers will have to choose the members amongst themselves, and for that purpose they can conduct an internal election. Now the central rules state that the employer will have to facilitate that election. He'll have to either put into place an electronic system of voting, so on and so forth. Next. So whenever a grievance arises, the worker will have to approach the grievance redressal committee within a year of the of the arising of the cause of action. And interestingly, this does not provide for any condonation of delay. So if I move before the grievance redressal committee, say after 1.5 years, the grievance redressal committee would not have the power to entertain my application because it would be beyond a period of 1 year. Next. So the court says that the grievance redressal committee may finish the proceedings within 30 days. It does not say shall. So it can continue after 30 days, but then the worker will have the liberty to approach the conciliation officer after 30 days or after the decision has been rendered by the grievance redressal committee. And a decision can only be put into place when it is agreed to by majority of these members, and this majority should again be inclusive of majority of the members of the workers as well. So unless and until you have the the ratification from majority of the workers' representatives, the decision would be no decision. Next. Next slide, please. Next. As I stated, that if this is not completed within 30 days or the report is not in favor of the workers, then they can approach the conciliation officer. And this application will have to be made to the conciliation officer within 60 days. Again, if it is not made within 60 days, then the conciliation officer has the liberty to not entertain that application at all. Next. Now, insofar as individual disputes are concerned, obviously the other disputes with respect to the grievance redressal committee, if I decide to approach the conciliation officer, I will need the imprimatur of the trade union as well, or the majority of my workers. They'll have to sponsor my dispute. But if it is an individual dispute, then I can approach the conciliation officer alone as well. Next, please. So if I then approach the conciliation officer, I will again have the liberty to approach the industrial tribunal within 45 days of me approaching the the conciliation officer. Then the industrial tribunal will have to entertain my application. So this is how the court contemplates two kinds of industrial dispute mechanism. The first one is through the grievance redressal committee, and the second one is independently, which happens nowadays as well, that you can approach the conciliation officer directly, and the conciliation officer can deal with your industrial dispute. Next slide, please. So coming on to the aspect of trade unions, if I have a single trade union in my establishment and the membership of that trade union is such that it exceeds 30% of the total workforce of my establishment, then in such an instance, that trade union would be the sole negotiating union. Now, if I have more than one trade unions and the membership of a single union exceeds 51% or more, then again, that union would be the sole negotiating union. But if there are multiple unions in my establishment such that none of them exceed 51%, and if each union exceeds 20% of the total workforce of my establishment, then each union will have to be given a seat in the negotiating council proportionate to the membership and the membership of the workforce. Next. So I'll not be dealing with this in great detail since I do not have much time left. Next. So this is a flowchart that I had prepared as to under which circumstances would you need to formulate a negotiating union, and under which circumstances would a negotiating council would be formed. You can take photos if you wish to. Next slide. So with respect to standing orders, earlier applicability of the industrial employment standing orders or the certification of standing orders was only necessary if you were employing more than 100 workers and if your establishment was an industrial establishment under the said Act. An industrial establishment under the said Act majorly only included mines, plantations and factories. But now the definition of establishment is such that it includes commercial establishments as well, your IT and ITS establishments, etc. For that purpose as well, you will have to certify your standing orders. Next, please. So this certification, next slide please, I've already discussed this. Next. Right. So you basically have two options. either you implement the model standing, of course, under the new labor codes, the model standing orders can only be issued by the central government, which it has already done. Under the earlier laws, even the state governments could prescribe their model standing orders, but now they cannot. Only the central government can. So if you decide to adapt the central government standing orders mutatis mutandis, then they'll automatically be applicable on you. You'll just have to inform the certifying officer that I am adopting the central government standing model standing orders, and if they have any observation to make, then they'll make those observations. But on the other hand, if you are certifying your own standing orders and you are making changes, etc., then you'll have to consult your negotiating council or your negotiating union or the trade union, etc. And after that, you'll have to share your the standing orders that you sought to certify to the authority. Now that authority will take this into consideration and it will certify the standing orders if it wishes to. Now, one interesting observation here, you only have 60 days to do this. So as soon as the state rules are notified in Telangana, you will have 60 days from the notification of the said rules to certify your standing orders. If you do not do that, then that would be a statutory violation. Now, in the interregnum, till the time you do not certify your rules, the model standing orders of the central government will be applicable upon you. So this is something that you'll need to keep in mind. And if you already have your standing orders certified, then those will continue. You'll just have to share it with the authority, and if the authority has any comments to make, then it will make. Otherwise, the standing orders that you currently have will continue to be in effect. Next slide. So I've discussed all of this. Next. Next, please. I've discussed all of this already. Next, please. Next. So these are certain key features of the model standing orders of the central government. I'll not be discussing these in great detail. But one feature which really stands out is that it has limited the probation period to 6 months, which can be extended to a further period of 3 months. So total 9 months probation is allowed. Now that automatically does not mean that after 9 months he'll become my employee, a permanent employee, because the Supreme Court has in many instances held that even if your appointment letter states that there's a 6-month probation, even after the completion of that period of probation, he does not automatically become an employee of mine. He'll still be a probationer unless and until an order is issued by me in writing stating that now you are a permanent employee and the probation period is over. Next, please. Next. So, mechanism for solving industrial disputes, as Niranjan sir initially said, that now you have an industrial tribunal which will comprise of 2 members, the judicial member and an administrative member. Obviously, the earlier labor courts and the industrial tribunals will be abolished when the appropriate time comes. But now what would happen is that all of these industrial disputes will be adjudicated mostly by a single member only, except those issues which have been clarified or have been specified under the code itself. So those matters pertaining to interpretation of standing orders, retrenchment, termination, they will compulsorily have to be dealt by both the members. And insofar as your mechanism of raising the industrial disputes is concerned, everything majorly remains the same, except the fact that now the power to make references has been taken away by the central by the appropriate governments and the central government, except in the case of national tribunals. So now if I approach the conciliation officer, the conciliation officer will obviously carry out his duties, but after 45 days he'll have to send a report to me as the employer, to the worker, as well as to the appropriate government. After receiving the report, the employee can then approach the industrial tribunal within 90 days. Now, if he does not do that within 90 days, will it be the position of law that he cannot raise an industrial dispute no longer? That will have to be seen. Further, a 2-year limitation period has been imposed. So earlier this limitation period was 3 years with respect to matters pertaining to termination, retrenchment, discharge, dismissal, etc. But now this limitation period has been extended upon all kinds of industrial disputes. whether it be an individual dispute pertaining to termination, etc., or whether it be a collective dispute as well. Next. Next. Next, please. So this is a flowchart that we have created pertaining to the raising of industrial dispute, the limitation period, and the timelines with respect to it. You can take a photograph if you want. I'll be moving ahead now. Next, please. This is considering the fact that I do not have much time left. I'll just be skipping over this. Next slide. Next. Next. Next, please. Right, so this is important. So with respect to your strikes, earlier it was not imperative for you to give a notice if you were carrying out strikes in an establishment which was not carrying out work of public eminence or of public importance. Right, now this concept has been removed altogether, and even in places where no public utility service is being carried out, you'll have to give a notice still. So a notice of 60 days will have to be given, and within that 60 days notice period, a further notice of 14 days has to be given. Only then can you carry out a strike. But under the earlier law, even if a conciliation proceeding was pending, and after the pendency of that conciliation proceedings or a week thereafter, you could conduct a strike, and that would ipso facto not be illegal. But now, even when you are conducting a strike during the pendency of a conciliation proceeding, that would automatically be illegal. Of course, the provisions pertaining to the strike being illegal when a matter is pending before the industrial tribunal 60 days thereafter, and during the subsistence of a settlement or an award pertaining to the subject matter of the strike, that would also be illegal, and that was always the case. Next, please. Next. So, retrenchment related provisions remain the same, except that the threshold has now been increased from 100 workers to 300 workers in respect of factories, mines and plantations. So if a person is working in a factory and the factory is employing a total of 330 workers, only then will I have to seek prior permission from the appropriate government before retrenching my workers. If there are 150 workers in a factory and I wish to retrench my workers, then I will not have to seek any permission from the workers. What I'll have to do instead is that I'll have to pay compensation at the rate of 15 days of work for every continued year of service. I'll have to pay them their notice pay, and then I'll have to issue a notice to the appropriate government. Remember that the twin obligation of paying retrenchment compensation and notice pay will have to be done on the date of the retrenchment itself or before that. If you do that after the date of the retrenchment, that would automatically be illegal. And the obligation pertaining to you issuing a notice to the appropriate government is again not mandatory, it is directory only, while the high courts of certain states have held that it is a mandatory requirement. The high courts of certain other states have held that it is directory and not mandatory. I remember reading a Karnataka High Court judgment, and Mr. Raju will be able to confirm this, where the Karnataka High Court had held that it is directory only, while the Delhi High Court and the Bombay High Courts both have held that it is a mandatory precondition. Right, so next slide please. I've discussed major provisions. Next, procedure I've already discussed. Right, so in case you are retrenching a worker, you will now have to pay some payment to the worker reskilling fund, and this payment will comprise of 15 days salary wages worth 15 days of work that the worker would have put in. Just remember that this payment will not have to be paid if you are closing your establishment, because that is not, or transfer of establishment, because that is not akin to retrenchment compensation, even though the amount that you pay would be equivalent to the retrenchment amount only. One thing to remember is that the central government has already notified the authorities for paying this reskilling fund amount, but this is to be notified by your state government as well. Next. This is really not important. Next. I think that I'm done with my presentation considering the fact that I do not have much time left. So that was it from my end. Thank you so much for your patience. I hope you had a good time. Thank you very much. we can take up the questions during the question and answer session, right?
Thanks, Rajat. It was really wonderful, and I really appreciate at this point of time, at this age, what level of expertise you are showing, and with the time and experience, when you will grow more, I believe the future of compliance, the future of labor law reporter, is very much in the safe and brighter hand now. And once again, please have a huge round of clap for Rajat Kumar, the editor of Labor Law Reporter. So now it's time to give you a little bit break from the labor code and have a different topic, but again related with the labor compliances. Here, ladies and gentlemen, I would like to invite Mr. S.K. Shetty, sir, the founder and Chief Executive Officer of Insurance Foundation of India, the author of One Cyber Attack Can Ruin you Forever, and the director of RIA Insurance. Sir.
It is nice to be with a large number of HR people, and I can recollect that in the 70s, the insurance world was associated with insurance of assets, and the accountant, chief accountant, or general manager finance was the person who was considered to be the dealing person or the decision maker. But with the coming up of IT industry, the importance has been given to the human aspect, that is human beings who are working in any organization. And now it is that in addition to assets, more and more policies are being taken by HR team. And the products which we as insurance broker deal with HR people are group term insurance, group personal accident insurance, keyman insurance, group gratuity, group EDLI, group superannuation, group health insurance, group wellness initiative, group leave encashment. So importance has become so much that I can take that when we approached one of the startup for Keyman Insurance, then the founder of the company was very hesitant in taking Keyman Insurance policy for 2 crore rupees, that is. But when this company started getting funding from foreign, then the shareholders or the investors from foreign insisted that his Keyman Insurance policy and also of the other co-founders should be increased to 25 crores and then later on 50 crores, and then it is that that person who is now that company is listed on the stock exchange is having Keyman Insurance policy of 100 crore rupees. That is the importance which the human beings are being given, and you are all familiar with it, that group term insurance or group health insurance are very common products and which are being done. Coming to the concept of gratuity, where we have been dealing with the corporates, that generally it is said that yes, we are following the Gratuity Act as and when someone resigns, then it is that whatever applicable, it is paid by our finance team. But then what is there is that in case you are paying that, you are not getting it under the expense head and you are also not getting the benefit under taxation. So under the Code of Social Security, now it is that gratuity insurance is required by you. So in case you are not having it, then you are, you can say, violating it to a great extent. But you are also not getting the benefit of the expenses being accounted for in the balance sheet, and you are correspondingly paying higher income tax than what you could have been you could have saved it as a part of tax planning. One of the fear which I find in the case of people, especially HR people, is that when we will go for gratuity insurance, then it is trust will have to be formed and how it will be done, and it is cumbersome and all that thing. That is why this point is deferred. But when you are going in for gratuity insurance policy from one of the life insurance company, then it is that the life insurance companies are capable of providing you with the support in some drafting, or they are having a set format for the trust deed, and all that support is provided. Now the steps involved in it are that when you think of that you should go in for group gratuity insurance, then you have to provide the data of the employees, date of joining, age, retirement, salary level, and then it is the life insurance company which uses their actuarial team to calculate that what is the liability which is becoming on you, that is as at present, and how it will be increasing. Many a time we find that when the actuarial team comes out that your liability at present is 5 crore rupees, then people say we don't have 5 crore funds available, that we form the trust and we put 5 crores in this, that is hand over to the life insurance company. So there it is that the life insurance companies give you the opportunity to pay it in 2, 3, 4 installments. So you can form the trust, you can give 1 crore rupees and let it be that is. And during the year when they have invested that 1 crore rupees on 31st of the March of every year, that is they will do again the actuarial calculation, and they say that how much your liability has now increased, what returns we have got from the investment which was made by us, and what is the difference which you have to pay now. So then it becomes a very smooth thing. See, what happens in the case of is that in case the money is within the company, then when there will be a need for something, some capital expenditure or something, tendency will be to use that fund, because it is in the hands of the same accountant or chief accountant that the money is lying and it will be spent. You do not realize it when, and that is this is a very normal business, that few persons have resigned after serving the company for 5 years, and that is you make the payment and all that thing. But when something serious happens, when there is a shutting down of the business, reduction of it, or maybe some application of the environmental law and compels you to shut the plant and all that thing, then it is that when all the persons are to be paid gratuity, at that time funds will not be available. And I am assuming it that most of you are employees, that is as employee, as HR manager, you have to protect your future and the future of your colleagues by going in for gratuity insurance policy from the one of the life insurance company. That is in your interest, it is in the interest of your colleagues, it is in the interest of your organization, because the part funding of this is being done because of the income tax saving which the company is having. And that's why it is suggested that you go for it. Now, how to select the life insurance company, that is role of an insurance brokerage firm like ours. That is, we can make you, or we can bring you in touch with maybe 3 different life insurance companies, and they make the presentation. What they will say is that the return which they got in last 3 years for their clients and all that thing, you take it, difference is very minute. Very minute difference is there. If someone is having 7.8, other will be having 7.7, or someone will be having 7.85. It is not much. But it's our experience that in case your fund is large, your gratuity liability is large, then it is people show more faith in Life Insurance Corporation of India because of its status, because it is very big and all that thing. But Life Insurance Corporation may not be interested in handling your gratuity when this amount involved is 20 lakhs rupees, 40 lakhs rupees. So then you are having the option of so many others. It can be SBI Life, it can be Kotak, it can be ICICI Prudential. So wide choice is available and our services are available for that one. Now, as it has been covered up is that wages thing which has been that basic salary has to be 50% of the CTC. So there the impact is coming very prominently because earlier with a view to save on the liability part, that is provident fund contribution or something that basic salary was kept at say 40% level. And now that when you will increase it to 50%, it will result in more contribution towards gratuity and more contribution towards provident fund. As a result of that, the take-home salary of the employee is going to be affected. And the employees are not going to be tuned to it that earlier I was getting a take-home salary of 45,000 and now it is getting reduced to 42,000. So therefore, some thinking is involved at your end and also at the end of the employees. That is how it has to be done. So these are the things which you have to keep it in mind. And one of the things which I will like to point out with this booklet is being distributed to you or soft copy will be provided, that human beings you are taking care of, statutory requirement you have to take care of, because then only the market capitalization or the value of your company is being created. What happens is that in case there is a violation, see, Gratuity Act says that when the person has resigned, within 3 days you have to make the gratuity payment. In case you do not make the payment and the matter goes up, then it is that there can be jail for 6 months to 2 years. In case a news item appears in the newspaper that such and such person has been arrested because of violation of Gratuity Act, it affects your borrowing capacity, it affects your value in the market and all that thing. So therefore you have to really protect the market capitalization of your company. Market capitalization can be talked in two terms. One method is that in case your company is listed, then it is the number of shares multiplied by the price on the stock market. Another way can be that the way these startups and the new era companies are taking shape, that more investment is coming from foreign and company still not a listed company, then it is that 10% of shares are sold for so many hundreds of crores, which means that market capitalization was estimated at 10 times of that amount which has been brought in. So with a view to protect the market capitalization of your company, growth of your company, you must take care of your human beings by having suitable insurance, gratuity insurance, group term insurance, group health insurance, and all that thing, because it is in your interest. If few words on group term insurance. In case some employee dies, and then it is that the people come, or then that is and he left behind his family and children are college going and how to take care of and all, and you agree that okay, now let us give a grant of 5 lakhs rupees. Next time again something happens, again you give 5 lakhs rupees, like that. then it is that you say, oh, there have been 3 deaths, and that is, and we have already paid, this time let us pay 3 lakhs. Now, when you reduce this type of amount, because the people are familiar with it, that when the death occurred, 5 lakhs was paid, and now it is 3 lakhs, that is the beginning of your industrial relations problem. That is the time when people start forming group and subgroups, and which affect your organization, and it results in industrial relations problem. So take care of it. Group term insurance, irrespective of the person is worker or senior, the person is having what color, what religion, what language and all that thing, and everyone will be paid as per the policy of group term insurance. So take care of your human resource very well, because you yourself are from human relations HR department, and wish you for the best of your organization. Because I will be leaving in case you are having a question or two and I can answer it. See, this is that is contractual labor or all that thing, that is for other advocates and legal people who are here to answer your questions. But our understanding is that there are some judgments of the Supreme Court and all that thing, which say that in case you are having contract labors being supplied by a vendor, then he should take care of that. In case he is not taking care of the statutory requirement, then the responsibility comes on you as the organization. So one has to be careful on this front, but the best advice will be given to you by Mr. S.K. Gupta and lawyers, that is.
Basically, prior to this code, there was no responsibility for payment of gratuity in respect of the contractor employee. But there is a 2 judgment decided by the one of the High Court of Maharashtra, and another actually by the Tamil Nadu. Okay. But the fact was this: if any casual employee is being engaged exclusively by the principal employer more than 5 years, if this evidence is coming before the controlling authority, then responsibility will go to the principal employer. Okay? If evidence does not come before the controlling authority that he has not worked exclusively 5 years, then it will not come. Because you are also knowing HR professional, you are giving a contract to many contractor, but the employee does not change. Employee will remain same. In that condition, you have to take care. Okay? But in the latest code on social security, the responsibility has also shifted to the principal employer. Okay? So you have to only ensure, I am saying, if the evidence is coming before the controlling authority that the principal employer has exclusively engaged for 5 years, then entitled.
My question is, if a person working in the company has become contractor.
Acha. As a worker is also working a contractor.
Yes.
Okay.
Worker has transferred as contractor.
Contractor.
Because I tried to become insurance.
This is a camouflage. Okay? And most of the court has also decided. This is one word. Because all your HR professional, you are all aware of this word. Okay? Am I right? Right.
Okay, sir. Thank you very much for time.
Please,
and
don't
we are
take
a
food.
all- we are always available to answer anything from the insurance angle because we are specialized in this direction.
I would advise why I actually called Mr. Sethi for your benefit, okay? Because if you go, you read the section 57 of the Social Security Code, which say that the state government is going to notify that every establishment has have a insurance against the gratuity. Against the gratuity. And I say it is good for the establishment. Why I am saying? Because once you are going to take the insurance, then the liability will shift it to the insurance. So that is the, you read section 57 of the Code on Social Security. And also advice to employer. This is I am saying, take the insurance. When you are taking insurance, your balance sheet is also remain healthy. Because you are not going to shift the liability of gratuity in the balance sheet. And another way, if you are going to take insurance against the gratuity, sir, you ask any income tax authority under section 43B, it will be treated as a expenses and you will get tax exemption.
Benefit. That's a
You
very
will get
big
a
advantage.
tax exemption. That's why insurance is now good for the organization.
See, assuming that income tax is 35%, it means that practically 1/3 is enough you are using out of that. And insurance company is very quick in when you inform them that this gratuity payment is due, and that is they and make the payment to your trust from where you have to issue the check, and trust formation and all, don't take it very cumbersome because it is very streamlined process, it's available. Thank you.
Thank you, Mr. Sethi Saab, for your wonderful session on this. And I hope many of employers who are available today will definitely going to take the advantage and look forward for covering their workmen and employees under the insurance. So now we are going to have our today's one of the leading actor for this entire event. Okay, ladies and gentlemen, today in this room we are having the member of Labor Code rules drafting for the state of Karnataka, the author for the only commentary book on the industrial relation code, the chief compliance officer offered to the Mr. Govinda Raj NS sir. Please come on the podium and have enlightenment to the entire audience, sir.
नहीं वो पीपीटी कर दो सेम ही है ना हाँ प्रेजेंट हाँ ठीक है ठीक है
Guys, please don't take pictures and photos. We will share your PPT on your WhatsApp group.
On WhatsApp and email, you will receive all those materials. Anything which Gupta ji or Govind Raju is going to commit, you will receive.
नहीं ठीक है Yeah. No mic is necessary. Thank you. Good afternoon, everyone. It's already a lunch time, and I am sure most of you are hungry. But the knowledge is very important, and be with me for another 45 minutes to 1 hour, and let me add value to all of you. And this OSH and WC code is a bigger code compared to all the other 3 codes, because there are 13 legislations are subsumed. And thank you Telangana, thank you all of you. Thank you Niranji and Niranjan Rawji, and also Gupta ji and all Click Nexi team. Yeah, our director is also there, Dr. Rahul. Thank you very much for bringing here. And let me begin my presentation. Next, anybody is there to? Yes, yeah. Yes,
Yeah, you are there. Okay, just go to the next slide. So I have around 25 years of experience, and there are 2 books in English which are authored by me. One is on industrial relations, basically managing labor relations, and the other one, which is the new one, on industrial relations code. This I took for last almost 4 years to write this book, reading extensively on the industrial relations code, because it was made as an act in 2020, and now it is a book for all of you. You can, there are some few copies are available, but if you don't get it today, this is also available in Amazon and also on mylaborcodes.com, so you can also purchase and read it. Next slide. Yeah, so see, this statute basically, talking about 13 legislations. नहीं, पहले जाओ. Just go, next go. Just go. Hold on. नहीं, उसमें क्या है? इसमें ये डाल देना. That services flow is not there. Sorry for the inconvenience. Go to the next slide, Raja. Yeah. So if you look at, in Indian labor law scenarios, I think Mr. Niranjan Rao ji already told that there are more than 44 legislation in India, and 29 legislations are subsumed currently into 4 codes. Go to the next slide. Yeah. So before I begin the OSH and WC code, let me remove certain, social media myths. The first one is, now all of you know that the basic salary has to be 50% of total remuneration. But if you look at the wage definition, there is nothing like that. You have to keep your 50% as basic. But what, according to me, what the code is talking about is the exclusions, whatever A to I we talk about, if it exceeds more than 50%, then whatever excess has to be added back. This also have a lot of impact on your salary restructure. I'm not going to talk more about it because Gupta ji is going to deal with in detail. So the next point is gratuity after 1 year. So this is also, you read in the social media that everybody is going to get a gratuity after 1 year of service, but actually in the labor codes it is not so. The continuous service of 5 years is going to be there for regular employees. Only in case of fixed term employees, this is now it is made, next one. It is pro rata basis, but that also has a conflict in the IR code, which I think Mr. Ajat has already clarified. In the IR code, it is talking about 1 year service, whereas in the code on social security, it is talking about pro rata gratuity. And the government also has the impression that the gratuity for fixed term employees is after completion of 1 year. So therefore, what they did is, in the code on social security, you can read rule number 33, which is already clarified that in the case of fixed term employees, it is 1 year gratuity, 1 year compulsory service is necessary, and if it is 6 months and above, you can take it as 1 year service. But whether it will have the test of law or it will be valid going ahead, I have my own reservations, because the code on social security, which is the parent legislation, which is talking about gratuity for fixed term employees on pro rata basis. If someone has got completed only 6 months, or you have engaged only for 9 months of service, then if he is leaving the service and if you don't give him a gratuity, then definitely the dispute is going to the court. So in our view, though it is a delegated legislation, cannot override the provisions of the code. So therefore, in our view, the code provisions will prevail, even in that case of 9 months or 10 months, whatever you engage. In that case, you will also have to give a gratuity on pro rata basis. The next one, exit dues within 2 days. This is also being talked that, if any employee leaves, all his dues have to be settled in 2 days. But actually, factually, as per the codes, this is very incorrect. This provision is coming from Code on Wages 2019. What the Code on Wages 2019 is talking about, only the wages earned have to be paid within 2 working days. Now, if I recall from the provisions of the code, there are 4 dues. Which are those? One is gratuity, leave encashment, and the bonus, and the wages. The bonus, you have a time limit of 8 months from the close of accounting year. And the wages, of course, now they are talking about 2 days. And the leave encashment, even in your Telangana, Shops and Establishment Act, it is talking about leave encashment within 2 working days. But in case of retirement, you have still 2 months of time. Now the left out is, the other one is the gratuity. Now the gratuity has got a time of 30 days. So therefore, if you have that understanding that all the dues have to be settled within 2 working days, that is incorrect understanding. Now let's go to the next one. Reskilling wages. So this is also talked about by Mr. Ajat. This is a one-time wage. Don't think that this 15 days wages for every completed year of service as a reskilling wages. This is a one-time. When you are retrenching someone, you have to give this 15 days wages. The next one. Yeah, contract labor cannot be used in core activities. So this is a straight provision under section 57 of OSH and WC code, but there are few exceptions. And I think, this is also, it is not new for you because Andhra and Telangana already had these provisions. Now those provisions have come up in the code in a revised manner, but there are exceptions. Only thing I'm telling you is, it's not a straight away prohibition. It has got some exceptions which people can exploit those exceptions. Next one, work from home officially recognized. Now, this is also being talked in social media that whenever any female employee goes for a maternity leave and when she comes back, to get a work from home facility, is it a right is the question. According to law, it is not a right. Because only when there is a feasibility, then with a mutual agreement and consent, the employer can provide this opportunity. So there is no straightaway provision that it has to be mandatory. So there is no such rule. And the last one is this 4 days per week. Work per week. So this has got 2 notions. One is employee will think that only I have to work for 4 days, and the employer will think in different way. Okay, so in 4 days per week, can I get the full 48 hours is the question. Now this all depends on the appropriate government provisions. If you look at from the employee point of view, that 48 hours per week is not going away. If you look at from the employer point of view, if the appropriate government notifies the proper provisions related to period of work and your rest interval and also spread over, then he will be able to use this provision. If there is no appropriate provisions, forget about this 4 days per week. If the time permits, I will also tell you what the central government is talking about and what your Telangana government is talking about on this spread over concept. Do you have a possibility or flexibility to get into 4 days per week? So, and what are the advantages and disadvantages we are going to talk about if the time permits. Go to the next one. So this what is common to all codes, I am not going to talk about it because you must have attended many programs already, and also Mr. Niranjan Rauji already talked about it in the morning. So therefore, I am not going to talk about what is common to all codes. Go next one. Yeah. So coverage and next one. So if you look at this legislation, there are 13 legislations are subsumed, which are mainly into factories, mines, dock works, BOCW, contract labor, ISMW, your working journalists and sales promotion employees, BD and cigar and cine workers. So these are the provisions, or these are the statutes which were there earlier. Now all have been now subsumed into one code. Next. Yeah. Now if you look at this code has got around 14 chapters. What is important for us is there are 2 chapters which are very important. Next one, the chapter 10 and chapter 11. The chapter 10 talks about special provisions for women employees, and Chapter 11 talks about special provisions for factories, mines, plantations, and BD and cigar. Now, what you should know by this is, the common chapters are applicable to every establishment and every employee. But whereas these special chapters are applicable to specific nature of employment or the business. Next. Now, if you look at this statute, there are 3 schedules. The first schedule talks about which are the hazardous process industries, and the second schedule, this is very important for you to know that now the central government can actually formulate the standards on occupational safety and health. So this is very important from the compliance point of view. Now the Schedule 3 talks about the list of notifiable diseases, and the Schedule 1 and Schedule 2 were there in the Factories Act 1948, and some of the provisions from the plantations have now been also taken so that it gets a complete code. Go to the next one. Yeah. So who can amend these schedules? Now, normally being a labor matter in the concurrent list, the statute making power is with both the central government and state government. But the beauty of this code is there are certain provisions where state has no provision at all. So likely these schedules cannot be amended by state government, but still using the power of legislative power, they can still make use of it and make an amendment, but which is go to the president, and then once the president assent is done, then that also will come into picture, considering that the labor matter is in the concurrent list. Otherwise, as of code is concerned, this schedule can be only amended by the central government. Go to the next one. Yeah. Now, if you look at all the 4 labor codes, you can see there is a best effort is made to balance the rights of the employees and the rights of the employers. Now, if you read each code, there are some provisions you will get. Now, in the OSH and WC code, let me tell you what employer has gained by the new provisions and what employees have gained by the new provisions. Next one. Yeah. Now, see, when you apply for a registration, if the registration is not coming up, or if the inspector is delaying, then there is a concept of deemed registration, which is good for the employer. And also I told you that the role of the central government is increasing. Especially if you look at the 4 codes, the IR code is largely the delegated legislation will come from appropriate government, the state government, and wage code also there is nothing much. But in the IR code there are some provisions like your model standing orders and other things are now getting prescribed by the central government. But rest of it, your delegated legislation is still the power of the appropriate government. But coming back to the OSH code and the code on social security, in the code on social security, Mr. Ejat is already spoke about it. If you have branches in more than one state, then the rules which you will read is the central government rules and not the state government rules. So therefore, if you have more establishment in more states or more than one state, your compliances are going to be easier because you will only go read one rule. Okay? And in the same way, in the OSH code, there are certain provisions which have a national application, which I will tell you going ahead. Because if you look at section 18, 23 and 24, that is the scope of only central government. There is no state with respect to safety, health and working conditions and welfare. Only the central government can make rules that will have a national implication. So therefore, the role of the appropriate government by virtue of these provisions has been narrowed down. Okay, so that is important for your compliance. Now coming back to this single license, I think single registration is already spoken about it, and no permission for overtime. Of course, shops and establishment had no criteria for permission for overtime and other provisions were not there, even in your Telangana provisions. But whereas if you look at Factories Act, Section 64 and Section 65 are very important. Section 64 was talking about there are certain exempted services where the appropriate government can make some rules, for example, for your repairs or emergency services and some special processes. You had an exception where up to 50 hours of overtime you can get it without permission. But under Section 65, there was a special power to the appropriate government or to the Inspector of Factories and Boilers, where for the exceptional press of work and other provisions, they can actually give you an exception, okay, or exemption. You are required to make an application so that you get a permission. So without the permission of factories inspector, practically you had no provision to get the work overtime done. So that is very clear. Now such a provision is not there. Even in your rules, appropriate government rules, Telangana and Karnataka, whatever the rules you read, so there is no such a provision where you require permission for overtime. So there is no requirement, but there are certain restrictions where the maximum number of hours overtime is already prescribed. So that we will also speak about it. Now, no restriction to engage women employees. This was basically, there were some restriction in the Factories Act for engaging of women employees from between 7 p.m. and 6 a.m. But many state governments have already notified amendments and made changes. The same thing is now in the code. There are no restriction for engaging women employees during the night shift, but only thing is the consent you are required to take care of, and there are certain safety provisions, transport and other things are there which you will have to comply. So that is also those restrictions and conditions are required to be notified or prescribed by your appropriate government. Now coming back to this electronic display, everything, this is all has come. And now if the factory can have common license. So now it is officially, there is no possibility for you to get double license for factory one and for contract labor one. So like that, there is no such provision, but you can get a combined or single license for that. Now if we talk about what are the employees' gains, one is a mandatory issue of appointment letter. Now with regard to this appointment letter, your regular terms of employment is different and the statutory appointment letter is different. Now, within 3 months from the date the rules of your state government comes into force, you are required to issue mandatorily statutory appointment letter where there are certain, minimum provisions have come with reference to salary, grade and other things. So that format, in that format you have to issue to every employee, and since the provisions are applicable to contract labor, even the contract labor also have to be given this appointment letter. But this similar provision was available in some of the state governments, in your S&D acts. For example, in Karnataka it is Form Q, and similarly in Telangana I have not read it, but could be there. So it is there, yeah. So some provision is there. Similarly, the same way, now the OSH code has also brought the same provisions. Now there are some restriction, prohibition on contract labor, we have talked about it, and annual medical checkup for employees over 40 years of age. See, if you look at this medical examination provisions, there is no common provision in the statute, only based on the nature of the industry and the work of the worker, what kind of work he does. In case of factory, if somebody is working for hazardous process or dangerous process, then there were medical examination provisions were there, once in 6 months and pre-employment, all those things were there. Now the code is prescribing that the state governments will have a power to prescribe this medical examination for all employees. Whether the state governments have utilized this opportunity or not, we will see. Because I don't think every appropriate government is using this opportunity to notify or prescribe rules for everyone. Because if you look at central government rules, central government is not telling for every employee. Earlier it was there in the draft rules, they were talking about a medical examination over 40 years, whoever has completed, that was mandatory. But that is not the situation now. If you read the draft rules and also the finalized rules, that is not the intention, because your appropriate government has the power to decide to whom it is mandatory. So that power, they are utilizing it. So that is one. And eligibility for earned leaves, I think Mr. Ejjat has already briefly talked about it. Now, instead of 240 days, now it has become the eligibility criteria is 180 days. And earlier, in case somebody joins after 1st January, there was 2/3 requirement was there. Now that requirement has become 1/4. The next one is leave encashment. Now, Telangana had leave encashment during the tenure of the services, but in the S&D Act. But if you look at Factories Act and other statutes, including plantation labor and other things, the Indian labor scenario, there is no leave encashment during the tenure of the service. Now the OSH code, since it is applicable to establishment which has got 10 or more workers, now it is a common provision where during the tenure of the services, the employee can demand leave encashment. There are two possibilities. One is, if it exceeds 30 days, he can get a leave encashment, he can ask for a leave encashment. And then at the end of the year, he can also ask for a leave encashment. These are two independent provisions. So these provisions have come. And in case of interstate migrant workers, there are additional protections have come. Now if you look at these ISMW provisions, this was only applicable where if you engage a worker from the contractor. If you look at interstate migrant worker definition, it was only applicable to the workers who have been hired through contractor. But now the definition is saying even if you hire directly or indirectly, so those are going to get a benefits or the additional protection because of this provision. But only criteria is if you hire someone from outside of your state and his wages is 18K and below, then only such people have to be covered under ISMW provision. Only criteria is you have to take care of the to and fro travel expenses, which is once in a year, and the rules are putting that if he has completed 180 days of service with you, then his once in a year travel cost have to be taken care. So these are the provisions which are coming in your appropriate government. Now there is also this public distribution system. All these things are going to be now, they will have a portability, and also some of, in case any deceased employee nominees are there, if the penalty is levied, some portion will also go to the dependents of such people. So these provisions have come. Now, very importantly is, I told you how to approach the compliance. Now, this is the time where you have to prepare your compliance checklist because the provisions have changed and the new rules have come. And the OSH and WC code is a very big statute where you have a role of central government, you have an appropriate government role as well in this code. Now, how do you approach? Now, let me tell you how you approach this code so that you can prepare, you can prepare your checklist based on these provisions. Don't think that only you will read the OSH and WC code and the rule of the Telangana state and you will prepare your compliance checklist. That is not going to work out because I have already told you, because of the provisions which are built in the OSH and WC code, the role of the central government has become more and more predominant. So therefore, you have to read the central rules, you have to read the code, you have to read the Telangana state rules, and whichever the state you are operating it, then prepare your checklist. So otherwise, your compliance checklist is not going to be full. Now, if you look at this code only covers these aspects or the coverage because these statutes have been subsumed. But very importantly, if you look at the establishment definition, it says if any establishment has employed 10 or more workers, then that establishment is covered in the OSH and WC code. So therefore, if there is no specifically mentioned that this provision is only applicable for factory, mine or plantation, then that provision is going to be applicable to every establishment. Now there is a conflict with your State Shops and Establishment Act also, that we will come to that point, I think already fairly dealt by Mr. Ajat. And now there are specific provisions. Now if you look at the definitions, there are specific definitions like factory, plantation, ISMW, all those things are there. Wherever there are specific chapters are available, then in order to make it applicable, you have to go to the specific provision and specific definition. Now, if you look at contract labor chapter, now the contract labor chapter is only applicable to 50 or more workers if you are engaged. So such a way, you have to read the definition and also specific provision and engage. Now, there is one more important for you is, now the factory definition has been changed. This factory now earlier, with the power 10 or more workers, without the power 20 or more workers. Now it is done 20 or more workers and 40 or more workers. Now that exclusive chapter which is there on the factory, now you have to read that definition, only a factory which has got 20 or more or 40 or more with or without the power, so those provisions are going to applicable. But for all other factories, the common provisions are going to be applicable. So that is how you are going to read the statutes. Next one is, so this is what common provisions and specific provisions. The next one is, central rules versus state rules. This is what I spoke about it. Now there is a role of central government, especially under section 18, 23 and 24. The welfare provisions, safety, health and working conditions are going to be prescribed by the central rules. So therefore, you have to read applicability for your establishment and then make your checklist. Next one. Employee versus worker. Now, if you look at the code, every code for the matter, they have defined separately employee and worker. Now, will you see these provisions as synonyms? According to me, it is not synonyms because they are different and distinct definitions. If at all the code wanted to treat these definitions as synonyms, they should have only defined one definition. Now there are two definitions, employee and worker. So therefore, wherever the employee word is coming, then you have to understand the employee definition, and employee covers everyone, okay, including your supervisors, managers, everyone. But the worker is not everyone. The employee, every employee is a worker, but worker, you have to see the worker definition only and then understand. If there is only worker in such a provision, then it is only going to be applicable for worker. Your supervisors and managers are not going to have any impact on those provisions. So that is very important. Now the next one is, yeah. So branches in more than one state. Now suppose if you have branches in more than one state, you have to also look into the provisions of such a state, and when it comes to registration requirement, your head office registration is not going to be applicable for such a branch. So such a appropriate government, you have to take a licensing and also follow the provisions of those statute or those rules for proper compliance. Next one. Yeah. Now if you look at the objective, see the objective is laws regulating the occupational safety, health and working conditions of the persons employed in establishment and connected matters. So therefore, that establishment word is very important. Next. Yeah, intersection with Shops and Establishment Act and specific state statutes. Now imagine, now I have told you this, because of this establishment definition, now this OSH and WC code is applicable to even establishments. Now what is going to do with your Shops and Establishment Act? Are you going to follow the Shops and Establishment Act, or you will follow the OSH and WC code? See, answer is, now if you look at the matters in the labor matters in the concurrent list, there is something called doctrine of repugnancy. Now according to me, my view is that if there is a possibility to obey both the laws, then according to me, you have to follow both the provisions. If there is a conflicting provision which is you cannot harmoniously read, it is my view, the other speakers may have a different view, but if there is a really conflict where you cannot follow that provision, then the repugnancy applies. But if you are able to follow both the provisions and make your complaints, then according to me, you have to follow both the provisions. And this fact also has been clarified by some of the state governments. I have read, like Maharashtra has clarified, Delhi has clarified that your state S&D Act is not going to be repealed. If at all they want to make it more easier, some amendment they can bring, like in Karnataka, it is being talked that the state S&D Act is going to be applicable for establishment which has got only less than 10 employees, and more than 10 employees, OSH and WC code is going to be applicable. But such a provision or amendment comes, then it is fine. But if it is not going to come, then both provisions will have overlapping provisions, and wherever beneficial provisions are there, which you will have to follow. Next one. Yeah. So specific employments. Now see, if you read the entire code and also the rules, the provisions are going to be specifically applicable to factory employees, BOCW, mines and plantation. So wherever when these things are coming, so then such provision is only going to be applicable. And the next one is, yeah, employer definition. See, understand this impact of employer definition. See, now if you look at employer definition, it covers the people or the employer who was employed directly and indirectly. So therefore, there is a principal employer responsibility also on the contract labor. This is the same definition, at least a majority of the definition has been brought from Minimum Wages Act 1948, and in one of the case it was so held that if the contractor is not honoring the provision, or if he is failing with the provision, then the principal employer is definitely held responsible. Now, with reference to the liability of contract labor in terms of bonus and gratuity, there were conflicting judgments were there because of the Payment of Wages Act provision, which is the wage definition. Now, with this employer definition, which is covering both principal employer and contractor as employer, now for all the dues of the contract labor, there's definitely, if the contractor fails, then there is a responsibility is cost on the principal employer to take care of it. And interestingly, the employer definition is same for every code, even under the IR code. So this will have a far-reaching effect on the provisions of the labor, and the litigation will be more, and it is good for the advocates naturally for the interpretation. So this is how the codes are coming. Now ISMW, I think we already spoke about it. Next one. Yeah, so registration requirement under the code. So if you are covering under the code, you have to get the registration. Now your appropriate government is already putting lot of rules in that. So follow that rules and get the registration within 60 days. Next one. Yeah. So this registration is establishment specific and not company specific. So therefore, if you have different establishment in different places, you are required to get the registration for such establishment. Now coming back to how about existing registrations? Does it mean that you have to get new registrations? See, answer is no, because there are provisions which are built in that you are required to update your registration details, and then if you don't update it, your license may be cancelled because the provisions have been put. So therefore, whenever the portal is giving you such an access, please update your registrations. So this is very important provisions. But now, next question will come, do SNDs require dual registrations? Now I have told you establishment definition is there. Because of that establishment definition, OSH and WC code is covering establishment also. But whereas Telangana State Shops and Establishment Act is already there, which is giving a registration. Now does that mean that you are required to get a registration under SND Act, also under OSH and WC code? See, this concept has not been clearly absorbed by the appropriate governments. Look at what is happening here is, some states are providing registration even for establishment also under the code. Especially you read, your Telangana draft rule. This is what I have read it. And also Maharashtra and Karnataka and central rules, these are talking about registration for every establishment. They are not going to talk about only for factory, BOCW, nothing. So there are registration requirements have been put into for every establishment. So therefore, if they don't amend the state's SND Act, you will have a dual registration. Definitely they will do something about it, but currently that is the status. And some states do not provide any registration provisions under the code for SNDs. Examples are, now Andhra Pradesh, your own neighboring state, so that is not talking about registration for establishment. So they are very specific. Similarly for Madhya Pradesh. And next question will come, if SNDs want to engage contract labor, now they have to get the registration under this code, not under the SND Act. So therefore, if they do not do anything about it, you will still have a registration if you want to engage contract labor. So that provision is going to come. Next, sir. Now, next provision is free of cost annual health examination of employees. Now, this is not a free and direct provision. What first thing is coming, it is not applicable to all the employees by default. Now, prescribing age, class of establishment, class of employees is all with the appropriate government, the state government or whichever is the appropriate government. So now if you look at, I have told you the central government, it is only prescribed this possibility for dock work and BOCW and mines employees. Don't think that without reading the provision of your appropriate government rules, don't conclude that every employee has to be medically or annual examination if he has completed 40 years. Earlier it was talking about 45 years. Now it is concluded as 40 years. Don't blindly think that. Unless you read your appropriate government definition, then based on that you have to approach. Go to the next one, sir. Now, look at your Telangana rules. Telangana is prescribes for every establishment, every employee completed 40 years of age within 120 days from the close of calendar year. So your appropriate government draft rules are talking about for everyone, but it is not for others. Next. Yeah. Now if you look at all these things, Andhra Pradesh, your neighboring state, and Madhya Pradesh, Karnataka, Maharashtra, these are all prescribing for only the workers working in factory, BOCW, BD and cigar, motor transport workers, and especially Karnataka, Maharashtra and AP, they are talking about over 40 years, but Madhya Pradesh is talking about 30 years. If you have an establishment in Madhya Pradesh and anybody has completed over and above 30 years, then annual health examination is mandatory. And issue of statutory appointment letter, we already spoke about it. Next. notice of accidents, dangerous occurrences, and also notice of occupational diseases. Now these provisions were already there in the Factories Act provisions, but now it is now OSH and WC code is capturing these provisions. Now question is whether every establishment is required to intimate is also. Now Factory Act was applicable to factory, so every factory was notifying. But now if you are the shops and establishment or IT or ITES, are you required to notify? Now again you have to read the provisions of your appropriate government. Look at central rules, Karnataka, Maharashtra and Telangana. These governments are making provisions that every establishment is required to notify. But whereas Gujarat, it's only mandates for factories and BOCW, whereas MP, your Madhya Pradesh prescribes for factory, BOCW, plantation and BD and cigar. And these timelines also differs based on your statute. Because only now the substantive provisions are there in the code, but whereas your appropriate government is required to prescribe the rules, you also have to look into those rules for application. Now, next one, sir. Safety committee. Now, safety committee provision is there under section 22. It is also not a provision which is very default provision. Don't think that the safety committee has to be formulated in every industry, because there is a requirement of general or specific order or a notification or prescribing in the rules is necessary. So therefore, unless the state government or the appropriate government prescribes this provision, then it is not a free flow or mandatory provisions. Now if you look at central rules, they are only prescribing for establishments employing 500 or more workers, and Madhya Pradesh talking about factory, BOCW, BD and cigar, and plantation with 500 or more workers. Go next. Yeah. So look at your rules. Telangana is talking about all establishment with 250 or more workers. Now all establishments, they are not talking about only specific. There is specific also, whereas in case of factory with 100 or more workers, and in case of hazardous process, there is no requirement of workers threshold. So therefore, this provision is very important. But as far as the draft rules are concerned, now Telangana is talking about every establishment, whether it is IT or ITES, based on the provision, or your retail industry. If you have this kind of manpower, you are required to also make this safety committee. Next. Yeah. So I talked about this health, safety, working conditions and welfare, especially under section 18, 23 and 24. So these are the provisions which have national application. All of you are required to follow the rules prescribed under this procedure, these provisions. So if you look at in these cases, there is no appropriate government role, because it is the purely prerogative of central government where it makes rules for national application. Now coming back to where it is prescribed. Now very interestingly is whether central government rules under these sections, has it touched the area of shops and establishment? There is no touching. So the central government has not touched the area of S&E. It is only prescribing common rules for factories, BOCW, mines, BD and cigar, motor transport workers, dock workers and plantation. So technically speaking, central government has the possibility to make the rules even for establishment, but it has not made. So therefore, because of these provisions, your S&E Act is going to be still valid in case of these matters. And next. Yeah, so with reference to all your latrines and urinals, there are different provisions are there. Now you read, if you read Factories Act provisions, there were different thresholds. Now the common thresholds for national applicability have come. So this presentation also will be shared so that you can note down this provision and check your complaints. Now see, one for every 25 male employees, you should have your latrines. So like this, there are, which are different provisions are there. Go to the next one. Go. Yeah, so similarly for urinals, one for every 15 employees. And now the sanitary napkins in your women's toilet is mandatory. So I have not seen this provision in Factories Act or any other provision, but now this is a very important provision. Next, canteen where 100 or more workers, and first aid training. At least 33% of your total workforce has to be trained in first aid. If you look at Factories Act, it was only talking about 10%, but now it is 33%. Next one. Ambulance room. So every factory, mine, BOCW, all these things, if you have 500 or more workers. And you are also required to appoint full-time medical practitioner directly. I have written these words are directly. So normally what is the process you will follow or how you engage? You must have taken from a retainer or a part-time or on a contract basis. But now the rules are talking about it is directly. On the roles of the company, the medical officer is required to be appointed. So next one, sir. Now the welfare officer, this is basically applicable for factory, mine and plantation. So one welfare officer between for 250 to 500 workers, and for women employees one additional, and also if you have 100 to 1000, so every one additional women welfare officer is required to be appointed. Now next. So creche facility, sir, creche. So this is also very important provision. Now this creche facility basically were, 2-3 statutes were earlier leading this provision. One was Factories Act, where you have 30 or more women workers, and under Maternity Benefit Act, where 50 or more employees, and there were some provisions in the mines and also in the plantation. So this was the creche facility. Largely, this provision was limited to the children of women employees. You agree with me? Okay. So now what is coming up is, if you read Code on Social Security provisions and also the OSH and WC code provisions, there is no gender specified. So therefore, there is no gender specified. Just go to the next one. Yeah. So if you read this provision, especially Rule 58 of Central Rules, now the creche is applicable wherein more than 50 or more workers ordinarily employed. A creche facility is provided and maintained for the use of children under the age of 6 years of employees. Sir, here there is no women employees written, sir. So therefore, the requirement is 50 or more workers. When you have 50 or more workers, the creche will become mandatory, and it should be used, it should be available for the children of all employees. So this is very important for you to understand. Next, sorry? Yeah, next one. So the mock drills has been made mandatory now. Yeah. Now I am coming to working hours. Now, sir, if you look at the OSH and WC code, it has got very simple provisions. What it is talking about is your daily hours cannot be more than 8 hours. And your period of work, rest interval, and spread over, all is with your appropriate government. You don't find it in the code. So therefore, prescribing this all is with the your appropriate government. And so therefore, in this aspect, your appropriate government rules are very important. Next one. Let's look at what your Telangana draft rules are talking about it. Now weekly 48 hours, it is talking about it, and other conditions are not prescribed in the rules. It is expected to be prescribed also the spread over and other things, rest interval, everything. But what they are saying is, there has to be a specific notification notifying your spread over, rest interval, and period of work. So unless if you have these three things, you cannot define what should be your working hours, how you can modify or how you can suit. So therefore, watch for this notification and then make your complaints. Next one, sir. So, yeah, weekly and go to the next one. Yeah, next one. Weekly and compensatory holidays. Now there is a requirement that you cannot require any worker for more than 6 days in a week. Now coming back to appropriate government has got a power to exempt some employee from this provision. Now let me tell you about compensatory holiday. This compensatory holiday is not a free flow provision. Okay. Now what industry is practicing and what the law talks about are entirely different, because industry is actually practicing, if you get a work from any worker or employee on a weekly holiday, what will you do? You will give a comp off. Is it aligned to the provisions of the law, labor law? According to me, it is not. Why? Because the compensatory leave or off is only possible when there is a deprive of weekly holiday by either in the rules or from the exempting orders of the government. Only in such a case, this compensatory off is possible. If there is no such a case, there is no exemption by the state government, or there is no exempting order providing this provision for taking work on weekly off, then only compensatory holiday is possible. Otherwise, if you are established, if your establishment has a provision or making a practice that you get a work done on weekly off and give a compensatory off as per your policy, that is actually not in line with the law. Go to the next one, sir. Yeah. Now, you had a provision in Factories Act. You technically had a possibility where if there is, in case of any emergency, you can actually require the worker to work on weekly holiday. The requirement was, there are two requirements. One was either before 3 days, within 3 days, or after next 3 days, you are required to give 1 weekly off, and then the notice has to be given to your inspector, and then you can take a work. But that possibility I didn't see in the OSH and WC code. There is no such provision. But in case if your appropriate government wants to have that provision, they can still notify that provision. Go to the next one. Now look at the Telangana draft rules. Compensatory holiday for sales promotion employees and working journalists if they are required to work on weekly holiday. Now there is a provision for sales promotion employees. In other cases, you have to read rule sub-rule of 250. Prescribed state may exempt any class of employees or establishment by notification. So therefore, in order to conclude this topic, you have to look into state government notification. If there are no notification exempting work on any weekly off, okay, then you may not be able to have compensatory leaves. So therefore, these notifications are very important. Next one, sir. Overtime hours and wages for overtime. Now these are very important provisions. Now, what constitute overtime work to be prescribed by appropriate government? Now, what statute is telling, you have to calculate overtime hours whichever benefits the worker. Now, working hours and leave with wages are largely applicable only for workers. There is no possibility for employees, or your supervisors and managers are not covered under this chapter. Now, the code, as I told you, the code only tells you have to calculate overtime work whichever benefits, the way it benefits. Therefore, now the appropriate government will prescribe, and period of overtime to be calculated based on daily or weekly, whichever benefits the worker. So this is the provision which your code is talking about. But consent is necessary, sir. In order to get overtime, so the consent is very much necessary. This provision was never there in the statute. Even in the Factories Act 1948, there was no provision for consent for overtime, but only the regulatory was prescribing the condition of consent before giving you a permission. But now, the overtime consent which has come. And limits on overtime work, number of hours of work, overtime work to be prescribed by AG, appropriate government. Now, how many hours you can take the overtime work? But shops and your S&D Act, I think it is 6 hours. 6 hours per week, okay? But in Factories Act, if you have a, exempting rules, if your state government had prescribed this exempting rules, you had a possibility to take overtime work up to 50 hours per quarter. And if you get a specific exemption for exceptional press of work, then you had a possibility of 75 in the Act, but based on your appropriate government, amendment, it could be more also, in up to 144 hours or 156 hours. Now that possibility now is with your appropriate government. Therefore, Telangana rules are very important. Now what the rules are talking about is more than 8 hours in a day, more than 48 hours in a week amounts to overtime. Now overtime work to be paid at the rate of ordinary rate of wages. This ordinary rate of wages is very important. It is not aligned to the wage definition, because if you look at the wage definition, is common for every purpose of the code, including overtime, leave encashment, everything. But how do they define ordinary rate of wages? If you look into ordinary rate of wages, it covers gross salary, which is as per the recent Supreme Court judgment. So that is, there is a ambiguity and conflict is also there. Now, I may also think that if somebody works for 30 minutes, will you give him overtime? Normally, no. So now the rules are telling that even if somebody works for 15 to 30 minutes, you have to round it off to 30 minutes, and more than 30 minutes, you have to round it off to 1 hour. And how do you calculate the overtime? Now, some establishments were also dividing the wages by 30, and some were doing by 26. Now there is a guideline, you have to divide the wages by 26 to arrive at single day wages, and divide it by 8 and multiply into 2 to get your overtime wages. So that is the this one is coming. Now this spread over condition can exceed what is prescribed or notified, including for exceptional press of work. Now section 65 of Factories Act was talking about this. For those reasons, your spread over can increase. Now, what are the restrictions? Is there any, for example, under section 64, weekly overtime work, what was the weekly restriction was 12 hours. Because weekly working hours was only 60 hours and including with the permission, whereas normal working hours is 48 hours, 60 minus 48 is 12 hours. So therefore, there was a weekly restriction of 12 hours and monthly restriction of 48 hours, and then quarterly based on your appropriate government, it could be 144 or 156. Now, the Telangana government is talking about in the rules, it is 156. Actually, 156 I don't understand. 144 is the correct logic. As per Factories Act provision 65, if you go, 12 fours are 48, 48 threes are 144. 156, I still don't understand the logic. On what basis? But it is beneficial provision for the employers because more number of hours of work, you are taking it. But unless you know what is the spread over restriction and what is the weekly restriction or what is the monthly restriction, this cannot be concluded. Otherwise, if the state government doesn't notify these restrictions, then that 156 hours I can use it anytime without the restriction. So there is where, and I am also doubtful whether the government has got it or not, people like Niranjan Rao ji, to educate the government so that they come up with appropriate, proper notifications. Go to the next one, sir. Yeah, overlapping of shifts. So this is very important. Rahul, stop me when it is required, okay? Otherwise, I will go on, okay? So this overlapping of shifts. Now this provision was also there in Factories Act, now it is section 29. You cannot engage any worker, or if you have different shifts or relay of shifts, they are operating the same machines or they are doing the same kind of work, you cannot have two relay of people or two kinds of people who actually work the same work. This is very important provision because if you have 24/7, your actual working hours has to be only 8 hours and 8 threes are 24. And if you give your period of notice to your inspector of factories and with some overlapping, for example, instead of 6 to 2, you give it 2:30, he never used to accept, he used to dispute. So he says his overlapping of shifts is not allowed. But such a provision, now look into your appropriate government, there is a 30 minutes for changeover in all factories is allowed. They have also allowed in certain kinds of industries like newspaper and other people, or in case of any auxiliary sections are there. So with the permission they are allowing, and there is a general provision is there where 30 minutes you can still, now if the same rules come into picture, finally, you can ask any worker to come 30 minutes additionally or before the shift starts, so that there can be a changeover possibility. So that provision, in the draft it is there, but finally if it comes, then it is good provision. Go to the next one. Restriction on double employment. So this was basically limited to only factory and mine. Factories Act also had this provision, section 30. Now what this talks about is, general rule is, if some worker has worked in the preceding 12 hours, okay, then he is not allowed to again re-employed by any factory or mine. Now there is a possibility for appropriate government to exempt from this provision in case of factory. Now if you look at next one. Yeah, so next one. Yeah, Telangana, now double employment is possible in case of factory and mine for part-time workers. Next one is employed in occasional nature of work and when the daily working hours does not exceed 8 hours. If somebody has only employed for 4 hours in a factory or mine, then there is a possibility for him to re-engage for another 4 hours by any other factory or mine. So that possibility there in the rules. Next one, sir. हो गया? क्या हो गया? जाओ जल्दी जाओ. Lunch time हो गया यार. People are hungry. Yeah. Next, next. So annual leave with wages. Now there are, next one, for sales promotion and working journalists, there are some exclusive provisions are there. But other than this, for normal workers, there are common provisions are there. One is, and these provisions are applicable to only workers. Because the worker word is there, this is not applicable to your supervisory and managerial people. For such people, you have to rely on your Shops and Establishment Act, because the statute is very clear on this front. There are two definitions. And this 180 days, which we have already told you, in case of, to become eligible now, only 180 days work is important. And in case somebody joins on after 1st January, it is 1/4 of the remaining days. So that provision has come. And 1 day for 20, that is already continued same. And yeah, next one. So leave accumulation and carry forward. Now leave accumulation, the law is telling you that he can accumulate up to 30 days. And if 30 days are exceeded, then he can ask for a engagement, encashment. And he also has a possibility to ask for encashment at any time. So that there are two independent provisions. Next. Yeah, due dates are same in case of discharge, dismissal, quitting, resignation within 2nd working days. And in case of superannuation and death, it is 2 months. And there are, in case of mines, there is specific provision under section 32(3), where if there is a beneficial provision in your industry, in your mine, then such a provision has to be followed. And section 120 is applicable to every establishment or every case. If you have a beneficial provision in your agreement or in your terms of employment or any other statute which is giving beneficial provision, then that provision has to be applied. Next. Contract labor I will not deal, because Mr. Ajat has already briefed about it, and you already had that law. But only what I'm going to tell you here is, now the contract labor licensing has gone to a different, state of change. Now every contractor will get two kinds of licenses. One is long term, the second one is work specific. He can get a license up to 5 years. And the second change is, he is not required to only go to the appropriate government, because if he wants to supply the contractors for contract labor for more than one state. Now the word is wants to or wish. It is not that he is actually supplying. If he wants to supply, then he can go to the central government and then take a license for which is got a pan-India application. Now if I read Andhra Pradesh and Telangana, both the rules, they are also telling that, they are also prescribing that he is not required to get a industry specific license. What the contract license is now is happening is, it is a industry specific. So you actually, as a principal employer, you give form 5 or whatever form 6 as per your state government rule, and then he will take a license which is applicable to only that industry. But that concept has gone. Now in the draft rules, what the provisions are coming is, if he wants to take a license for entire applicability of your state or district, he can also apply for such a license. So that is possibility has been built into your draft rules. If the same rules comes, then definitely the contractor will have a single license policy for every establishment. He is not required to go for a industry specific license. So that possibility has been brought. And only compulsory is, whenever he gets any work order, he is required to intimate the registering authority. Now because of online everything, now he is also possibility to upload in the portal. So that is provisions have come. Next. Core activity, this I'm not going to deal with this provision. Next one. Go. Yeah, next. So, coming back to Factories Act conclusions. Now I told you, because of the overlapping provisions where central government has got exclusive provisions, it has prescribed already common provisions for safety, health and working conditions. Now what is the role of the appropriate government? Definitely you will ask this question, but that is why now there are some specific provisions which are built in. One is licensing or registration, your plan approval, your on-site committee for hazardous process industries, and any specific provisions related to hazardous process or dangerous process. All these provisions are going to be prescribed by your appropriate government. So therefore, in case of these kind of specific establishment, there may be an overlap of provisions with the central government rules as well as state government rules, because occupational health center requirement is not there under the central rules. occupational health center requirement is there only under the appropriate government using the exclusive provisions which are available to the appropriate government. So your occupational health center, your appointment of doctors in case of hazardous process or dangerous process, these kind of establishments, they have the possibility. And even medical examination, pre-employment and periodic medical examination and testing of your equipments and pressure vessels, all those things provisions are still with the appropriate government. And if I read the appropriate government rules, now they have come up with a big list of hazardous process and dangerous process list. So each and every process has got a specific provision. So if you are coming under such a provision, you have to read that schedule and make your compliance checklist accordingly. So largely, conclusion is overall there is a role of central government for common applicability, but exclusive applicability to certain extent in case of hazardous process or dangerous process. All these things provisions are still left to the appropriate government provision. Go to the next one, sir. Yeah, there is a common license possibility which I have told you. Now under section 119, a factory can get a joint license including contract labor, and also if you are say industrial premises for BD and cigar workers, then they can also take including contract for engaging contract labor. So any combination of the three is possible. Only exclusively for contract labor, exclusively for running factory, or exclusively running for BD and cigar. So this is possible, and appropriate government rules have already built into the concept already. These provisions are already coming up in your draft rules. Okay, thank you.
Ladies and gentlemen, now we are given 30 minutes break or lunch break. You can join. After 30 minutes, we will session again continue. Thank you once again. Thank you.